May I please, my lord?
Yes.
Lordship, I please for adjournment of item number 17, my lord.
Item number
17, my lord.
17.
Yes, my lord. CD may not be
Then
received,
8.
my lord. List after
Okay.
2 weeks, my lord.
Case diary.
Here, CD received.
A date may fixed, my lord. Lordship, I could not. Lordship, I could not have lordship voice, my lord.
I'll take up the bails first. Motion bails.
Okay, ma'am.
They've been pending since yesterday.
Okay, ma'am.
Then we'll go to other matters. Just hold on for some time.
Yes, ma'am.
Respected counsel.
Item number 1. Your Lordship.
May I, Your Lordship? Your Lordship, I would like to mention item number 10, that is WPS 0125 for adjournment. As the leading counsel is out of station due to some
Item 10?
emergencies. Item number 10,
Diary has been, this is for admission. Okay. Pair of the learning, adjourn. 1 week.
yeah, it's okay.
On the ground that leading counsel is outstation.
Much obliged.
Any more mention? No.
Item number 1.
Yes.
Allegation is section 69. False maybe for.
Yeah.
Their Lordship, unfortunately, both of them were in relationship for more than 10 years. It would amount to 3,650 days more. They were together only in the month of June 2025. Some misunderstanding crop up between the complainant and the alleged applicant. That has already been resolved few days back by through a mutual settlement agreement. Only for some few days when the informant have made any telephonic call to the applicant, he has not received his call. He ignores, distance himself. They are taking the only evidence, but there is no any ingredients of deceitful in the FIR also, and both are grown up, Your Lordship. The informant is a divorcee, and the applicant also is a divorcee.
They are getting married now.
They are now in good terms, only because in the month of June there was a torrent by the applicant.
Okay. Anything, Adam? We'll call for the case diary, but with some interim protections.
In the meantime, interim maybe.
Yes. 482 bail application. Okay. In connection with Khonsa PS case number 19 of 2025 under section 69 BNS. The allegation against the petitioner made by the informant is about having sexual intercourse with her and with deceitful means and false promise of marriage. It is submitted by the learned counsel that the parties are in a relationship for several years, and subsequently there was some problem in the relationship leading to the filing of this case. Instant case, it is also submitted that in the meantime the parties have reconciled and an agreement has also been made, a copy of which is annexed with the petition. It's to call for the case diary of Khonsa PS case. However, in the interim, in the event of arrest, 15,000 with one security section of the arresting authority, and subject to the condition that he shall cooperate with the investigation and make himself available for examination, and shall not hamper or tamper with evidence or in any manner or shall not harm or harass the informant in any manner. Okay. List after 2 weeks.
On 19th, Your Lordship.
1911.
Item number 2.
Take short cycles, huh? Both of them. Short, 20 minutes.
Yeah, it's a lot.
Yes.
It's a lot.
Lordship, we need some more time to seek the instruction, Lordship. We have already
Bail,
provided.
cancellation of bail.
Yes, Lordship. Lordship, if possible, tomorrow, Lordship.
Tomorrow, it will be before the senior court. I will not be available tomorrow.
Lordship, first up, Lordship.
No, I have taken whole leave.
Oh,
Yes.
tomorrow you won't be
I have to-
available. Yeah. Oh.
Today on 2 p.m.
Go for some medical. I have to inquire about someone.
Lordship,
In
today,
Dibrugarh.
at 2 p.m. I'll try to.
You take the, we'll
Yes,
for two, at 2 p.m. Okay.
I'll try, Lordship.
Okay, we'll try. Let us keep it for 2 p.m. Otherwise, we'll fix it on
Monday, Lordship.
Monday. maybe.
Yes, Lordship. Much obliged.
Bless.
Item number 3.
May I, my lord? My lord, this is an application cancellation of the bail, my lord. The petitioner before my lord is a complainant and also the father of the deceased, my lord. Now, my lord, what has happened here? Just on 23rd October 2025, my lord, a young man aged about 20 years of age was found dead in his rented house, my lord.
Yes, yes.
And it was purportedly a suicide.
Right.
So, my lord, now from his room, 4 handwritten suicide notes were also found, my lord.
Mhm.
And systematically blaming, my lord,
This person.
disclosing the systematic mental harassment, sexual exploitation, corruption related, so and so forth, my lord. This is and he said the responsibility is of 2 persons, 2 officers. Now, what happened is one of the officer committed suicide after hearing all this, came in the media, social media. One of the officer who was
One of the kind of accused.
so to say. So he committed suicide by shooting himself.
Really.
And the other officer, my lord, who is a senior IAS officer, by then he was posted in Delhi, my lord. He went on hiding. Now, suddenly, my lord, then thereafter, my lord, ascertaining that that was a suicide note and who was responsible, I have filed a complaint, my lord. I've lodged an FIR. And my lord, thereafter, what happened on 27th October? 27 October, the officer appears, goes to the police station, surrenders, and was produced before the court, my lord. And now he was remanded to 14 days of judicial custody. Now, when the judicial custody, the SIT has just begun the investigations, then he was granted bail within 5 days, my lord. Now, the bail order is, my lord, I should not be using at the temple of justice, my lord, such word like perversity, my lord. But I can't help myself but to use this word. If my lord will just come and see the bail order, the bail order itself has discredited the suicide note, where even the investigation hasn't begun. And also, my lord, the bail order has also, my lord, try to, my lord, character assassinate the young man, my lord, by saying that this man was mentally disbalanced person. Therefore, he committed suicide. This kind of order doesn't come normally in the bail order, my lord. So, my lord, may I just take my lord directly to paragraph 5.
Page.
Page 15, my lord. Page 15. This is the submissions. I'm just taking my lord to the submissions of the SIT, my lord. Why
Okay, in the bail order.
Yes, my lord. May I just read, my lord? Paragraph 5. It is submitted by learned additional SPP appearing for SIT that the present case is initially registered as UD case and thereafter regular case by Nirjuli PS case number 9225 under section 108, 271, 272, section 3(5) of the BNS is registered. The case is handed over to SIT for investigation only for 6 days, and the SIT has already started its investigation and interrogated the accused person at judicial custody after taking permission from the court. It is submitted that the accused person has given different dates since when he was in contact with the deceased, as the CDRs and other materials does not support his depositions. It is submitted that the accused person used different phone numbers, and the SIT needs more time for collecting the CDRs and the said phone numbers used by accused person. It is submitted There was several WhatsApp chats and voice messages exchanged between the accused and the deceased, but the said chats were deleted from the mobile of the accused and deceased, and accordingly, SIT has forwarded mobile handset of the accused and the deceased to FSL examination for retrieving the deleted WhatsApp chats and voice message. It is submitted there are incident even when voice messages were sent from toilet and the same was deleted before coming out from the toilet. It is submitted that the investigation of the case is at the initial stage and releasing the accused person may result in hamper and tamper with the investigation, as the accused is not a layman but an IAS officer, and there is every possibility that this release on bail may hamper investigation of the case. It is prayed that the accused person may not be released on bail at this stage of investigations. My lord, we can skip what my lawyer have submitted at that point of time, and my lord may kindly come to page 17, my lord, now. Page 17, the paragraph 9, my lord. I'm just, for the purpose of notice, my lord, I'm just referring to the paragraphs that would be relevant. Now, before considering the material placed before this court, we have examined the law for the time being enforced. Earlier, as provided under section 309, an attempt to commit suicide considered to be an offense. Said offense of attempt to suicide is criminalized after enactment of Mental Health 2017. Now, an enactment of BNS suicide or an attempt to suicide does not consider to be an offense. However, there is no doubt that such an act of suicide clearly reveals unbalanced mental health of the deceased. My lord, with due respect to the departed soul, my lord, I feel this is not a proper way of passing an order and using this, my lord. In a present case, allegation against Mr. So-and-so is for commission of offense under section 108, 271, 272 BNS. Section 271 of BNS provides that. Now he goes on to say, my lord, what are these provisions of law says, my lord. And my lord may kindly come to para 18, my lord, para 18, para 18, I'm sorry, page 18, para 12, my lord.
Okay,
Yes, my lord.
the allegation as per.
Yes, my lord. The allegations as per suicide note against Mr. So-and-so is that if the disease was not received in the post, he would not commit suicide because of so-and-so. He did those things and there is no way left of living. He was peacefully studying in college with a better life. And people are thinking that how they met. So in Facebook, after that on WhatsApp, and they had an affair. He then recruited him in a post. Deceased would request CBI to investigate so-and-so as he has many black money and illegal properties. But so and so forth, then my lord goes on and then passes an order, my lord, in a detailed order, my lord. The detailed order, but failed to consider my lord. So my lord, at this point, my lord, because as anyway, my lord, the right of the accused person must be.
Fair enough.
Yes,
You'll
my
issue a notice.
lord, I'm deeply
Fair
obliged, my lord.
Okay. Issue a notice.
Yes, my lord.
And you must have implemented him also.
Yes, my lord. Respondent number 2 as the accused, my lord.
The respondent number 2, namely so-and-so, who stated to be a senior civil servant in the senior civil servant belonging to the IS, is an accused in NRJ Nirjuli.
Yes, my lord.
PS case number 92 of 2025 under section so-and-so, section will find in page 14, right? I've underlined. He was subsequently granted bail on 4/11/2025 by the learned session judge UP Arunachal Pradesh. the petitioner, who is the father of the deceased / victim, has invoked the jurisdiction of section 4823 within bracket 3 BMSS for cancellation of this bail granted to the respond number 2. The grounds were of seeking cancellation, you must have mentioned.
Yes, my lord.
The grounds of seeking cancellation have been mentioned, 8 of the petition.
Yes.
This is a criminal petition, right?
Yes.
At this stage, notice may be issued to the respondents, especially respond number 2. I will send it by registered post.
My lord, yes, we send a registered post, my lord.
Registered post. Nowadays, AD does not come. So tracking, postal tracking.
My lord,
through
my
the
lord.
registry.
We'll submit a,
The copy may be furnished to the prosecution as well.
my lord. I have already received.
Already, the prosecution has already been furnished. Copies list on. When should I?
For the Thursday, my lord, if it's not inconvenience, my lord.
No, no, it's okay. I won't be here.
My lord,
No problem.
Thursday, my lord.
Thursday will be which date? 20, 2011.
My lord.
When-
Matter number 4.
Obliged. Lordship.
May I please, Lord, sir. Lordship, this is joint criminal petition for quashing of FIR and charge sheet on the basis of settlement arrived between the parties.
Yes.
So, Lordship, the accused person before your Lordship is a minor, juvenile, CCW, and child in conflict with law.
Okay.
So, FIR was filed by the petitioner number 1
Mhm.
against some unknown person,
Mhm.
alleging that some secretly film has been, her photo has been taken by someone, and that has been uploaded, Lordship. And after, on receipt of said FIR, it was registered being Itanagar Women PS case number 11 of 25 under section 77, 79 of BNS, read with section 66E, 67, 67A of IT Act laws. Lordship, thereafter, within 15 days,
Yeah.
when the complainant came to know that it was, the allegation was against the minor, accordingly, settlement was arrived between the parties. And thereafter, they also filed a joint criminal petition, Lordship, before this honorable court. In fantasy, again, it was came to know there's some, these 3 petitioners, 2, 3, and 4, they have also lost the FIR. But
Against the.
yes,
person.
against some unknown
Oh,
person,
okay,
against
yeah.
that minor, Lordship.
Several girls are there.
Yes, yes. Now, thereafter, again, Lordship, subsequent settlement, it was then the earlier criminal petition 90 of 25 was withdrawn, and this subsequent application has been filed.
Okay.
Lordship.
Let us see, get the case diary.
Yes,
No?
Lordship, Lordship, is can
Short date. No, not really. Get the, it's at the stage of investigation.
Lordship,
Charge sheet has been filed, Lordship, and Lordship, summon has been issued. Lordship, I have enclosed the summon.
on the last occasion, Lordship, PCR was called for in criminal petition number 90, Lordship. It was
Rising out of the same.
yes,
Yes.
Lordship. And TCR was called for and Lordship, the petition number 90 was withdrawn the previous day, Lordship.
On 11th only,
On
Lordship.
11th,
I
Lordship.
see.
So record might be with the registry.
I
So
see.
may I amplify that records may be.
Yes, yes.
Yes.
It is submitted by the learned prosecutor that the scan TCR of Itanagar Women WPS case number 11 of 2025 pertaining to the present proceeding was called for in connection with another criminal petition which was subsequently withdrawn.
Yes.
Full stop. In this petition, the petitioner is seeking quashing of the criminal proceedings, which are stated to be at the stage of appearance
Yes.
after filing of charge sheet. So we can ask the registry.
Yes.
The registry may place the TCR, scan TCR before this court if it is still available.
Available.
So list the matter on Monday.
Monday or Tuesday, anything.
Tuesday.
Tuesday.
That's okay. Tuesday on the on Tuesday, this you can, if it's not disposed of, then you can make your interim prayer.
Yes.
List on 18 letter. Okay, because it seems there are some other girls also involved.
Yes, sir.
Yes.
So we have to see.
Yes.
Different.
Item number 5.
Deeply obliged.
Yes, sir.
Malat, in this matter, Malat, we are challenging for quashing of FIR charges, Malat.
Mhm.
Malat, this is very old case. Basically, it is a 30 years old case, Malat.
Really?
Malat, matter was, the complaint was basically in this, this criminal petition,
Mhm.
number 1 is a complainant and number 2 is accused in that
Okay.
complaint.
They have settled the matter.
They have settled the matter and they have filed the withdrawal letter also in 1995. So it's in page 10. Page 10 is a simple letter which shows that the matter has been settled among themselves. So that is in the page page 10 and 11 is a type copy.
I've got it.
Yes, you lost it.
There's this is one B.
Yes.
Shriyam.
With due respect, I have the order to inform you that I have lodged a complaint against such and such. But the case has been settled amicably among us according to the local cabal.
Vinod Miri, yeah?
Yes.
And he's Bengia Xingyang.
Even question is petition number, the petition number 2. Then they were thinking the matter was settled, but then suddenly charge sheet, they were not aware that charge sheet was also filed.
Came to be filed.
Yes, filed on is the page 12. Page 12 on 31st/5/1994 under section 307, 392, 326 and 506 IPC, page 15.
Can I see the FIR? Please?
Malat, FIR, Malat, it's not available on the record.
So
we have filed a CTC of that application. Your Lordship may see the last page 21. We have showed for the certified copy of FIR, charge sheet and orders, but then they have not supplied because they said that the FIR is not on the record. So that's how,
Anyway, this can be, but
My lord, I'll make submission on, firstly, my lord, I will make submission on this, the very petition itself. My lord will come in the prayer part, my lord. Page number 7. Then I will come on the, my lord, the preferring this delay and losses will come in this case, my lord. I will say in page number 7.
yeah.
A writ of certiorari shall not be issued. How it would be a writ, my lord.
No,
That is need to be corrected. And
it's not a writ.
yes.
It's not a writ.
And second part, my lord.
Exercising 482 or 528 BNSS is in substance like a criminal writ,
Exactly.
but not writ in that conventional sense.
Yes,
And
exactly.
And we understand.
Because
It's only
why?
2632 to decide.
Yes, why I am saying so, because my lord, it has been held that when cognizance has been taken, then writ petition is not maintainable for quashing of the criminal proceeding. For that, on that ground, I am raising this issue. And second part, my lord, as my learned senior colleague has stated that they have preferring this criminal petition after 30 years, my lord. So now 30 years, why there is so much delay in preferring this criminal petition, my lord?
What is the date of this?
I will just, in fact, Malat, I have just taken to that orders, Malat. I will just take to the orders, Malat.
We can get the records at this stage.
Yeah.
What do you say?
Yes, my lord, my objection on the delay and losses may kindly be
Yes,
recorded.
I will record it.
Yes,
Well, I will come to that delay lectures also, Malat. Malat, because I'm for the interim for
What is the last order?
Last order,
13/10/2025.
yes, last order, Malat.
For CC.
non-bailable warrant has been issued.
Okay.
And my lord, here in this case, your lordship, the section register is under 307, my lord. It's a non-compoundable offense. And your lordship, and same cannot be withdrawn, my lord. There is nothing to show in the record. They have settled the matter, my lord. And it cannot be withdrawn, my lord.
I will just take to the how this matter has been pending long time. Just my lord, I will just take to the this one, page 16. Page 16, you'll also may see the page 16. I'll just read the page 16, you'll also. Page 16 is DC has received the charge. At that time, the judiciary and the executive was not separated.
Yes, obviously.
That's time the DC has received on
Way back.
24/8/1994. DC Anini received charge sheet. That's in page 16. Now, what happened after that? Nothing happened, my lord. I'll just take to the after that matter was placed before the judicial magistrate first class Anini. Your lordship may see the page 17. Page 17. I will just page 17. May I read that order? So the order dated 11/06/2024. May I read that one? Case record put up today. Upon receiving the same from the Office of Deputy Commissioner, Dibang Valley District, Anini on 5/6/2024. So this was received from the Deputy Commissioner almost after 30 years, Your Lordship. And then Perus of the Seer rebel that IU or such and such stated the case such and such against the above accused named person, which is exclusively tribal by the session court. Then what happened? This matter was again referred back to session court. I will come to that order, my lordship may see. As for the order dated 21/2024, your lordship may see the page 18. 18. Now this the matter was placed before the judicial magistrate first class. Now judicial magistrate first class placed the matter saying that this is being a session tribal, so it should be placed before the district and session just stage. So I may just read that one important paragraph, second paragraph.
It was committed. The case was committed.
Yes. So may I just read the second paragraph? Since the offense 307 IPC is exclusively tribal by the Honorable Session Court, Teju, accordingly, the present case is committed to the Honorable Session Court Teju as per the Section 209 of CRPC. The sister is directed to send all the case records documents in original to the Honorable Court of Session Teju along with the seized articles, if any, for further trial. And the BI is directed to notify the learned PP of the commitment of the case to the Honorable Session Court. So accordingly, this matter was placed before the session court. Now the session court was the matter came up in the session court on 13. Your lordship may note down 13/10/2025. It's in page 20.
I've seen.
Yes, page 20 is. May I just read one? Case is fixed today for the consideration of charge. I have not annexed the earlier order. Accused is absent with the step being the NBWA issued against the accused was called void order dated 26/09/2025. Hence, the accused has remained absent despite the notice case fixed today. Issue NBW against the accused with notice on. So next, last line. In absence of the accused, learned PP case is adjourned. List the matter on 18/11, the coming 18/11/2025. So matter is being of 30 years. I will just place some of the judgments.
What is the date of the charge sheet?
Yes, charge sheet was filed before a deputy commissioner is on 31.
Filed in time only.
Yes, 31.
What happened in all these years?
My lord,
Yes.
What went wrong?
the judiciary was not separated at the
Yeah.
point of time. my
It
lord.
remained pending.
Yes, my lord. So later on, when it was separated, your lordship, all the record has been transmitted to the concerned judicial
But it's,
magistrate, my lord, and then now it has been
Very
committed.
long time. Anyway,
And my lord, the second part is, my lord, here is a prevailing NBWA is been issued against the accused, my lord. And here they are simply saying that they try to withdraw this case. Now it's a 307, my lord. The
In
section
fact,
is 307.
I am praying for the stay of the whole proceeding. We are praying for the quashing whole proceeding.
Yes.
Well, I will just take to some of one two judgment, my lord. Your lordship may just I want to play that one. One is of
at this stage, I think let us do that. And
My lord, issue notice and call for the record, my lord.
but I will pray for the
Since, the next date is just the doorstep. Till the next date, he can be protected.
Yes, my lord, then NBWA, this non-bailable warrant
It has
will
to
be,
be
my lord, that will become infructuous, my lord,
That,
if it is
that
stayed.
has to be stayed.
Yes, my lord.
That has to be, let him appear on the
Yes,
next day.
yes.
You have appear.
But,
But,
or my lord, my lord may
You
kindly
record your
protect him
appearance.
till he file an appropriate application for recall of the NBWA, my lord.
No, my lord. I will just pray that, my lord, this similar petition, it is 30 years old, my lord. Otherwise,
It's
even
okay.
even 17 years
It's
old,
okay, we'll see.
matter was stay
That's
and
okay.
quash, my lord. I will
That-
just,
that maybe.
Yes.
That's,
so I will pray for the stay of that
Third,
process.
learned counsel for the petitioner and additional PP for the state. The petitioner has invoked the jurisdiction under 528 BNSS seeking quashing of the criminal proceedings pertaining to dash Anini PS case number 6 of 1994 within bracket GR number 11 of 2024 and charge sheet number 10 of 1995 under section 307, 342, 326, 506 IPC. Full stop. The FIR stated to have been lodged in 1994 itself, and though the petitioner has applied for a certified copy of the same, but he has not yet been provided, as it could not be found. Is stated to be not yet found in the record. It is submitted, drawing attention to Annexure 1. It is submitted that by this letter, it was informed to the IO by the petitioner, by the informant, right?
Yes.
Letter was
By the complainant.
by the informant that that he had settled the matter with the accused. Full stop. However, later the charge sheet came to be filed,
On 31st,
and
5,
case after committal is presently at the stage of as of appearance and consideration of charge. Full stop. Filed order dated 13/10/25. The learned session judge was pleased to issue NBWA, fixing the next date on 18/11/2025. Full stop. We'll call for scan TCR.
Yes, my lord.
Call for the scan TCR from the concerned police station. Considering the fact that the FIR dates back to 1994 itself, and the petitioners have indicated materials have shown materials, right? Shown materials indicating some settlement between the parties. Therefore, it is directed that till the next date of listing, further proceedings in GR so and so shall remain stayed. The NBW issued against him shall also remain stayed, subject to the condition that he shall appear on the next date, that is 18/11, and seek recall of the NBW. The stay of further proceeding shall come into force after that. After that, you appear on seek
Yes,
recall,
yes,
and
okay.
after that, after the aforesaid exercise on 18/11/2025. Right. Yeah. Above, madam, above, you just write that the learned additional PP objects to the petition, submitting that there is long delay, and also submits that one of the penal provision is section 307, which cannot be compromised. Okay, this
And-
much is sufficient.
And my lord, one more, my lord, there is no any settlement deed in this present application.
That'll come later on.
My lord, that may be
It is also
recorded. my lord.
submitted that it is also submitted that no settlement deed / agreement has been placed on record.
Yes, my lord.
This is the matter
After 3 weeks, my lord.
after 3 weeks.
Yes. Obliged, deeply obliged.
Item number 6. Writ petition.
May I please, Your Lordship?
What is this about?
My lord, the petitioner is the one of the, my lord, amongst the candidates who were, my lord, terminated from the PRT, my lord,
Okay.
serving under the Department of, my lord, Education, my lord.
Let's pass similar orders,
My-
right?
Yes.
The other day. We have taken, or I don't know who had taken this. At least similar order. What we had said in that order passed.
My lord, to the respondent number
Do
2.
you have any copy of that order?
Yes,
Yes,
my
but
lord.
they have
And
annexed it,
page
my-
number, my lord.
Page 79 of rate.
Oh, yes.
One petitioner, my lord, and respondent altogether, my lord, 5 respondents, my lord.
Okay.
And she is serving as
How many petitioners are here?
1, my lord.
Only one.
Yes.
Only one.
Well, madam, this is 79, page 79, the similar order is there. Here, there is only one petition. Rest of the order will be same.
In place of 12 respondents, my lord, only 5 respondents. my lord.
5 respondents.
Yes,
5 respondents.
yes. And she was serving as, my lord, the PRT, my lord.
Copies, you furnish copies?
My
The other side. Right. Oh, it was disposed of.
Yes,
Yes, already.
I see.
Same direction.
Verification and.
My lord, that if they found the authority. will
Disposed of
come.
on similar lines. Just make it identical and change it.
develop.
Item number 11. It's a bail matter.
May I please, Your Lordship? Your Lordship, here, the accused was arrested for the offense under section 21B, 27A, and 29 of NDPS Act.
Right.
Your Lordship, during the consideration of charge,
Mhm.
two sections, namely section 27A and
Yeah.
29, 27A and 29
Yeah.
have been dropped.
Dropped.
The only 21B is standing against the accused person.
So the rigors of 37 will
Not
not be
applied,
applicable now. Because we have to go by the section which is at present, the latest section. Anyway, so
Your Lordship,
just come up for the first time or no? Hearing. TCR has been received.
yes. Your Lordship, as for the FIR, Your Lordship, the amount that has over from the accused is 44.36 gram.
Hmm.
However, Your Lordship, judicial record
Hmm.
shows that only 7.4 gram was recovered from the
The sampling,
sampling. When
inventory.
yes, therefore, Your Lordship, the charge sheet has been frame against
Intermediate quantity
intermediate only for 7.4 grams.
of heroin.
Yes, Your Lordship. And Your Lordship may kindly come to the judicial
Yeah, originally it was stated to be 44.36 grams.
for yes,
Even that is intermediate quantity.
intermediate. But Your Lordship, this.
Can you show me the charge order, please?
Page number 17,
17?
17.
I see. Prosecution, yes, ma'am.
Your Lordship, there's one issue I would like
Wait,
to apprise.
just 1 minute. When was the arrest?
Arrested on 7/4/2025.
7/4/2000.
2007 has been passed.
Okay.
So Your Lordship, here, Your Lordship, recovery was made, alleged to be made from the accused person. However, Your Lordship, the recovery was made from the public bathroom, which can be accessed by multiple people in the building. Civil Secretary. Your Lordship, Your Lordship will peruse the statement of the,
He was a staff in the secretariat.
yes, Your Lordship, he was,
He was not a staff as such.
Your Lordship, previously he was working
Oh,
in
yeah,
the,
bro, he allegedly brought the drugs for sale within the secretariat.
In fact, he had no address as such.
Anyway, whatever it is.
Your Lordship, this is the statement of the prosecution. Your Lordship, here, Your Lordship may kindly come to page number 33. May I read, please? On being examined by the police, I am serving as a sweeper in Civil Secretariat, Itanagar Government of Arunachal Pradesh. On dated 7/4/2025 at around 14 hours, I was cleaning the toilet at Block B building at AP Civil Secretariat, Itanagar. While cleaning, I noticed one floating bag lying on the side of toilet wall. Upon picking up the polythene bag, I found some small plastic vial containing colorful small plastic inside the tube and some serum. As such, I informed him the matter to SO Govind Sanwar to verify the matter, as it seems to be serious matter. Your Lordship, it was, Your Lordship, already
Where's the fire? Just help me with the page number. Anyway,
Page number 85.
85. Now, what, trial must have progressed to some extent.
It has progressed a lot. I'll just apprise Your Lordship, but there was a small issue which was apprised to this honorable court, and the honorable court as such has directed for the record of the trial court, Your Lordship. If Your Lordship will come to page number 16, Your Lordship.
16.
There was an issue if the bail was filed before the trial court, and what's the order of the bail, Your Lordship. At page number 16, Your Lordship will see.
Yes.
Above, Your Lordship will see BA number 382 of 2025.
Yes.
In so and so cases, Your Lordship.
Ah.
The bail was fixed on 13/8/2025, Your Lordship.
Yes.
But the bail was never taken up, Your Lordship.
It was put up, it was directed to be put up along with the
Along with the main case.
petition charge hearing.
Now, if Your Lordship will come to the main case, which is at page number 17, Your Lordship.
Yes, 13.
There is no reference to the bail application, Your Lordship.
There's no reference.
And
to
that
the
was-
petition.
That was the issue before this honorable court on the earlier occasions, that what is the
Status.
stage of that bail application?
Oh.
Because there is no rejection order, no granting order,
Right,
Your
right.
Lordship.
Your Lordship will find, Your Lordship, in the order it is clearly stated, Your Lordship.
Yeah, you can also take the,
Your Lordship, it was taken up, bail matter was taken up simultaneously with the main
if
case.
it is pending, then you have to withdraw one of them, right?
Absolutely.
Your
Because-
choice,
No,
because-
Your Lordship,
since
it
you
was,
have concurrent jurisdiction.
Because if that is pending, Your Lordship, this honorable court, there would be two bail application pending before.
Mutual respect, you know, although
Your
The
Lordship,
other,
higher, more than that, it's more, all our courts,
Yes.
concurrent jurisdiction courts.
yes.
So,
Your Lordship, clearly, Your Lordship, the rejection was pronounced in the open court.
but it was not, but where is there's no
Bail order, Your Lordship, has not been forwarded yet.
It's
Your
not
Lordship.
even in the case.
Your Lordship,
Long time.
when I consulted in the lower court yesterday, they have confirmed that the bail order has been forwarded to the High Court.
No, Your Lordship, I have gone through the TCR, Your Lordship. There is no rejection order of that particular bail application, Your Lordship.
Who can,
It was-
who can find out this?
Your Lordship can
You find out? But
Your Lordship can
some-
direct me
you
to
can
other best, because on the other.
take instructions.
Yes, I'll take
Let her take instructions.
Your
We'll fix it on Monday.
Your Lordship, 20 or 20 or fine. All right,
Heard. You are Mr. Kamchan,
Mr. Khan.
Genie, additional public prosecutor for the state. Otherwise,
Yes, Your Lordship, accused was not even communicated at the ground of his arrest.
from the materials, it is revealed that though one bail petition was filed before the jurisdictional session judge, special judge, and directed to be put up along with the charge hearing, but it is not reflected. The outcome of the bail application is not reflected in the order dated 13/8/2025 framing charge against the accused under section 21B NDPS Act, full stop. The additional fairly submits that she will take instructions regarding the status of the bail application for the purpose of adjudication of the instant bail petition arising out of the same FIR. List the matter on. You want it on 20? List on 20.
If I may,
TCR has been received and may be returned. Scan TCR has been received and may be retained.
Your Lordship, write the number of the bail application, which is 382
Yes.
of 2025.
Being bail application number 382 of
2025.
2025.
Deeply.
Obliged.
Item number 12. Within bracket, you will write Itanagar PS case number 55 of 20.
May it please your lordship,
Just
your lordship,
Yes.
in this case, I would not like to go to the merits of the case, but state that since the prosecution is taking indefinite time in the completion of the trial, the petitioner has been staying in the jail since the arrest of him on dated 13 November 2020 till now 13 November 2025. That is,
what are the sections?
the sections are
So 302.
120 clause B, 302, 316, 201 and 34 of IPC, Your Honor, Your Lordship. And also, Your Lordship, in this case, the man accused, Mr. Lishironi, was been granted bail by the Honorable Supreme Court of India on 23 September 2025. And Your Lordship, may I read the grounds
Yes,
that the Supreme Court has
I've seen
stated?
I've seen that.
Yes, Your Honor.
22 witnesses have been examined.
Yes.
Unless there is some special reason, I think he should also be granted.
Yes, Your Lordship.
Yes, Your Honor. So, yes, Your Lordship. So on this ground only, we are seeking for the release of
Trial
the
has progressed. Okay, he's been in
petitioner.
a long time.
Your Lordship, I just need
Yes.
some clarification to,
Yes.
since, the person who has been granted bail by the Supreme Court,
Mhm.
I have seen the record of a very recent order of November 2025. Your Lordship. Seems he's still in the custody because his remand has been continuously being forwarded.
No, he is on release, Your Honor. He's on release on record.
He has been released.
He's
in the
been
meantime.
released.
This bail application is more on parity, Your Lordship. I don't,
No, parity is not automatic, but still, we can take a view.
only on the
Yes,
fact
yes.
that the trial has.
Yeah, that's true, but 4 years,
Your Lordship,
unless there's some specific.
from today, it has completed 5 years.
Not to grant bail, otherwise person should be as far as possible on bail during trial, as far as possible.
Yes.
But there are maybe some reasons where to deprive, right? So,
Prima facie, there is a case, otherwise, as per the observation of the apex court, Your Lordship, only that the trial.
all these depositions are there. It's a case of 302.
302.
Yes, Your Honor. Your Lordship.
Must be, the allegations must be serious, right?
The part played by all the accused is of different nature, Your Lordship.
These are all depositions and order sheets. Anyway, so. It's very difficult. It's somehow tied in a different direction.
Your Lordship, may I read out the Supreme Court order dated 23 September?
Yes, I have already gone through, but you can read.
Yes, no. Your Honor, in paragraph 3 to 4, it stated, after the charges were framed,
23rd September.
yes, after the charges were framed, 22 witnesses out of total 43 witnesses as on that have been examined. 6 witnesses have been directed to be recalled. Therefore, the completion of the trial to take sufficient time. The petitioner was arrested on 10/11/2020 and is suffering incarceration ever since. In the facts and circumstances of the case, keeping in view the personal liberty of the petitioner in mind, we consider it appropriate to enlarge the petitioner on bail. Your Lordship, the prolonged remand of the petitioner will be miscarriage of justice.
Can we write? Bail application 125, I think it's 12. The accused petitioner herein, namely so-and-so, was arrested on 13/11/2020 in connection with Bandardeva PS case number 22 of 2022, which in a charge sheet after completion of investigation and subsequent registration of sessions case number 2 of 2021. Charges have been framed against 6 accused persons, 7 accused persons. How many accused persons are there totally?
Four.
For 7 accused to a charge sheet
One of them were discharged, Your Lordship.
expired.
Discharged.
Discharge, I see. So charge was framed against
5.
subsequently charge was framed against 5 accused persons, including the present petitioner under section 120B 302 316 201 34 IPC. And the case is at the stage of trial. The primary contention of the learned counsel is that his prolonged detention it has caused prejudice to him, especially in the context of the fact that the trial is yet to be completed. Drawing attention to an order dated 23/9/2025 passed by the Honorable Supreme Court, granting bail to co-accused Lisi Soni. It is submitted that his case for bail also should be considered similarly. In that order of Honorable Apex Court, it was mentioned that out of 43 witnesses, 22 witnesses have been examined, and 6 witnesses have been recalled, have been directed to be recalled. The learned additional public prosecutor submits that the nature of the alleged offences are serious in nature. The scanned TCR has been received. Considering the length of detention, the progress of trial, and the aspect of parity vis-a-vis the bail granted by the Honorable Supreme Court to the co-accused, then you give a dash. I deem it fit to grant bail to the accused at this stage. Accordingly, he is allowed to go. But 50,000 will be, can he manage 50,000, 30,000?
30,000.
30,000
Your Honor.
with one surety of the like amount to the satisfaction of the concerned learned court. And subject to the conditions that number 1, he shall be available during the remaining trial. He shall not hamper or temporary dividends. He shall not harass or harm or threaten any witnesses. The bail petition stands allowed and disposed of on the aforesaid. Right.
Oblige, Your Lordship. Item number 13.
May I please, my lord? My lord, I'm not pressing this application on the merits of the allegation, my lord. My only submission is only confined to the legality of the arrest. Because the parameters drawn by the Honorable Apex Court in catena of authorities as well as the coordinate bench of this Honorable Court and also the division bench, which mandates that the grounds of arrest has to be given.
Where is the notice? Let's see the notice.
I kindly have page number 51 to understand the gist of the case.
Mhm.
It's the FIR which was filed. Initially, case was registered under section 308, which is extortion.
Hmm.
Later, criminal conspiracy, unlawful activities has been added.
All right.
Page number 54, that is the arrest memo.
48, 47 notice?
No notice that we issue.
It's not there.
No. Well, okay.
Can you kindly check from here, the 47, 48 notes? That means you are seeking bail on the grounds of the principles laid down in Vihan Kumar.
Vihan Kumar, Prabir, and the authorities of our honorable coordinate benches. My lord, may I kindly have page number 54, my lord.
Arrest memo.
Yes, my lord. This starts from para 10. If I may read.
Only,
Reasons from now.
only ticked.
Yes, my lord. Only to prevent,
Prevent,
accuse,
yeah.
all those things. This has
for
been
investigation.
settled by.
Anyway, 47, let learned PP say, check it once. He did not give you that notice?
No,
It's
ma'am.
not furnished to you? Notice must be there.
But
The
there's one
contents may not meet up.
Yesterday, I have received one intimation, arrest intimation. But that intimation, in fact, is very generic and vague, my lord. It does not qualify the requirement under section 47 as well as article 22, my lord. Gone through intimation, my lord. My lord may kindly have that.
Notice of arrest,
Arrest.
59.
Grounds of arrest, my lord. It only says that you are being arrested for your alleged involvement in the commission of the offense. Above mentioned offenses. As per the information and investigation made so far, as there are reasonable grounds to believe that your arrest is necessary to prevent the commission of the further offenses, ensure your proper identification, secure your presence during investigation, my lord. That cannot be a grounds of arrest. To justify grounds of arrest, my lord, the material facts, the role of the accused, basing on which he was arrested, has to be given, my lord. So it does not qualify the requirement under section 47 as well as article 22.
It is partly correct.
My lord.
Some grounds are there.
Yes, my lord. The basic facts which necessitate the arrest.
But these are more generic.
Generally.
Actually. No, this is okay. Ensure your identification. This is specific. Commission of further offenses. That is also generic. Secure your presence during investigation. This is also generic and trial. Prevent tampering with evidence.
My lord.
Or influencing witness. Purpose of fair, complete, and lawful investigation. This is also. This is you received this by
Yes, my lord.
electronic mode.
My lord.
This should be there in the document. When was he arrested? 15/9.
15/9.
Under what are the provisions?
Section, my lord.
308.
308. 61, 13 UAP Act, my lord.
13 UAP Act.
UAP
Yes.
Act. Punishment for unlawful activities.
13 UAP Act. The 47D2 that will not come. That will not come.
Any statutory embargo will have no effect, my lord.
No, that will not come because it's only for sections chapter 4 and 6.
6.
Chapter 4 starts with section 15, which is the definition of terrorist act.
Yes, madam.
Right? 13 is, I think, committing unlawful activities.
Yes.
That is the thing. Only 13 has been given. Only 13 has been given. Could you find this notice? No, you couldn't find. You find this notice, no, which he has just.
That's my arrest memo notice, madam. It is German, 100 page number 114.
This one is there, the same. Yes, can you write?
My lord is severe, but I have made some compilation of the judgment I have submitted.
No need. The heard and so on. The instant bail application has been filed under 483 BNS seeking bail for Marley Ingo, who was in connection with Nijuli PS case number 77 of 25 under section 308 of section 2/61 BNS. Read with 61 is terrorist act, right? It's terrorist
13.
act.
61 is
ENS, my lord, criminal conspiracy.
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 My lord,
161 BNS read with section 13 of EWA P Act, within bracket P Act. Yes,
my lord, I have objection, my lord.
yes, yes.
Yes.
But the thing is that this is the notice, right?
Yes, my lord. But my lord, if you use the CD, my lord, CD I have given, my lord.
Okay.
Case diary, my lord.
No, because if we find that the notice is not does not comply with the stipulated requirements,
Case
then
diary
bail has to be given.
My lord, case diary is ground of arrest is mentioned is stated in the my lord, case diary, my lord, in the second page, my lord. Yes, in that very page, my lord, that my lord, which my lord has just well, earlier page, yes.
This one.
Yes, my lord. Second page, my lord.
No, that's okay. But the thing is that the grounds of arrest has to be provided to these people, the arrested people,
Yes, my lord.
as per the law. And wherever this it has not been done or it falls short, then irrespective of the merits, we are having to grant bail. All over India, this is happening. But anyway, the IOs just have to learn and follow that. Now, earlier they didn't know. This law had come, only start coming from the end of 2024 and crystallized in 2025. So earlier the formats were different, so didn't know. But anyway, people got the benefit. But now that learning window is not there. Now IOs must know how to follow. Anyway.
My lord, that my
Can't
lord,
help
Mr.
it.
Perry's, my lord, page number 114, my lord. That is an intimation letter of arrest memo, my lord.
Date 15.
114, my lord.
He's written also 47, 48. But 48 notice is. His
100.
accused name is Tana Padang.
No, my lord. Marley Ingo.
Sorry, Marley Ingo, yes. Arrest memo of Marley Ingo was different now.
Page number 50. 54.
No, my lord.
No, of
Case
the
diary,
of
case diary.
the record. Could you find?
My lord, page number 14 to page number 19, my lord, may have
Yeah.
look. Yes, my lord. From the CD, my lord.
14. No, there are a lot of materials. No doubt about that. No doubt about that.
Yes, my lord. Prima facie material is against the accused person, my lord. And offense involved is section 13 of the APA, my lord. And the alleged accused person.
If it requires some elaborate hearing, then we'll keep it for Monday because I have some time constraints today.
My lord,
But otherwise, if prima facie this is we have to go only by this 47, 48 notice, then
my lord, I'm under custody since last 60 days, my lord. And the requirement under section
Allegations
47
are
has
there.
not also been complied.
My lord, as per section 47.
you can do one thing, this is available here in this.
Yes, my lord.
Oh,
Yes.
yeah,
Yes.
just now it's in this. What was the page number that indicated regarding this?
My lord, page number 114 to 119, my lord.
Yes, 100.
14 to 119. This is here.
Pertaining to this person.
Pertaining to that person, my lord.
The other person I found.
118 or 19, my lord, we have.
No, 114 is with another.
18, my,
Another, Humsa, Pansa.
18 and 19, my lord.
No.
Then, my lord, I will be allowed to find out, my lord.
You can.
My lord,
Yeah. Or you take instructions and you will
kindly,
have a hearing.
my lord, my rights are being violated. My
No,
kindly consider this today. My
because there are so many materials that
Yes.
determination, if bail has to be granted on technical grounds, it is kindly.
The prosecution has only to show that whether a ground of arrest has been provided or not.
Yes.
That much, my lord.
Yes. If
Not on
if
merit.
bail has to be given on these grounds, the 42D3, that's a stringent provision of rigor, which is
The tune test,
that
my
like
lord.
37, that is not applicable
Applicable.
with regard to section 13.
This-
Normal bail application.
Yes, ma'am.
But in the context of large volume of apparently large volume of materials. I have not gone into detail. That if bail has to be granted on the non-compliance with 47 and 48, then we have to be sure about it that there has been no compliance, right? Or inadequate compliance. So in that, kindly see that document. Kindly see that document. Because both sides we have to give time. I would have fixed it tomorrow, but I won't be here tomorrow. Monday.
This has been fixed yesterday, and then on the last also CD was
there whole day. So
Therefore,
otherwise,
kindly
they could
consider
have taken. Heard so and so. The petitioner who was arrested on 15/9/2025 in connection with Nirjuli PS case number 75 of 2025 is seeking regular bail. The penal provisions given at this stage are sections 3082. I did not. You give that only. 61 BNS read with section 13 UAP. That is also I have dictated. The accused was arrested on 15/9/2025. The learned counsel for the petitioner submits that he is not going into the merits of the matter and seeks bail on the ground of non-compliance with the requirements under section 47, 48 BNSS pertaining to notice at the time of arrest of the petitioner. And in the context of the laws laid down in this regard by the Honorable Supreme Court in the cases of Bihan Kumar and Pravir Purkastra. The case diary has been received. The case diary reveals extensive investigation. The learned public prosecutor submits that there are significant incriminating materials against the petitioner. So, who do you find that?
My lord,
You do not find. Kindly take actions then.
Yes.
When you read,
kindly
post it for hearing.
possible for a time being, my lord. Kindly, it's a matter of my right, my lord. I've been since under custody.
My lord,
since
may
last
possible
3 years.
matter in minute.
For a time being, my lord. For a time being, that's kindly. Grateful.
The second half, I have some constraints. No? But okay, you find out. It will remain till then.
Item number 14.
TCR has been proceed.
My lord, what happened is on 37 July 2025, there was a collision between two vehicles, one Fortuner and one Tata Sumo, wherein it was found that the Fortuner was an stolen property, and the person who has been arrested took my name, my involvement in that car racket. Therefore, I was arrested. In fact, for the main case, for that illegal car trafficking, already one case was registered. I was arrested and I was granted bail. Now this case, in fact, those sections charges against me doesn't attract to me in this case. The charges are section 35, 3 under bracket 5, 61, 217. These are for those who receives or retain the stolen property. However, for involvement, since my name has been taken in this case, so another case is there in Itanagar, which bail has already been granted. And all the prime accused, co-accused has been granted bail.
Where's the FIR of the present accused?
FIR is
Page 14?
page number
Page 14.
Page number 14.
And his name is TCR.
My name is
Lordship, last occasion, Lordship, we have submitted that it is already charged being submitted, Lordship. So, Lordship, we have called for the teacher, but
Can copy of diary and
yes,
charge.
record will be there, Lordship.
Record would be there.
Yes, Lordship, in the Lordship record, Lordship. TCR has not received, Lordship.
Case diary will be necessary.
Lordship, it's already submitted as a charge sheet, yes, Lordship. So we'll call for the TCR, Lordship. Scan copy of TCR.
Scan for
yes, Lordship.
I have already spent around 90 days.
I see.
And all the co-accused has been released on
And he
bail.
can be released also maybe, but.
Lordship, but
without
we have to go
it's
through the
true, yeah,
record,
it's
yes,
true.
because Lordship, as per the allegation, Lordship, this,
Racket is the involvement in
Lordship.
racket.
during disclosure only, Lordship, his name is revealed, Lordship. So we got through the Lordship records once.
His name is,
Saddam
No. Sagar Burman.
Ajay Burman, Lordship.
Sagar Burman, no? This
I was actually a private driver.
accident or is it bad? It's unfortunate. Yeah.
Lordship, the ground of, Lordship, here, Lordship, ground of rejection of the bail, Lordship, before the session judge, Lordship, it is there in page 19 and 20.
No, it's okay. You can take a
No,
fresh view also.
Yeah,
in
but-
High Court. Yeah, it's not bad.
Next week, Lordship, till then,
No,
second copy. of the
Which
case.
district?
Yeah.
Papumpare.
This
Yeah,
session, UPR, Lordship.
Okay.
Well,
Yeah,
this
Monday.
is the fourth time this case is listed for CD, calling CD, but
Lordship, already submitted charge sheet, Lordship,
Okay.
as we have already informed this court on the last occasion, Lordship.
It's okay.
in fact, my lord, for the main case, Itanagar PS case, wherein the investigation and all for this
Just,
car trapping has been carried.
Hold on, sir, because it's a kind of racket. This has to be
Okay.
seen, record has to be seen, right?
In
Without
that case,
record-
my lord, I have already been granted bail in Itanagar PS.
No, I think interim will not be justified in this case. But get it on, can we get it on Tuesday, Wednesday?
Lordship, and Lordship,
Tuesday?
not next.
Will it come Tuesday?
Yes, Lordship,
Wednesday?
will. TCR, Lordship, it's going to be
TCR.
TCR, it's nearby UPI.
Yeah, okay. What will be the realistic date, earliest realistic date?
Lordship,
Wednesday?
2-3 days, it,
When is,
to Tuesday, it.
Wednesday will be safe.
Yes, Lordship.
Heard. Uh, It is submitted by the prosecution that in the meantime, the case has been charged sheet. Call for the scan copy of case diary and charge sheet from the concerned learned court, which is the court of the learned session judge.
Yes, Lordship.
Session judge Papumpare, UPI. Papumpare is the district.
The
right?
district, yes,
Yes,
Lordship.
and UPI is the headquarters.
Yes, Lordship.
Where I am also staying.
Lordship, knowing everything, Lordship, this place.
So this is the matter on. I can give on when Tuesday, but I don't know whether it will come.
Monday.
Tuesday. Monday may
It's
not,
been
may not come.
already-
Tuesday. Let's take a chance.
18 November, Lordship.
On 3 occasions, we had
No, no.
call.
Have faith, she will get it.
No,
No, she will get it. 18-11.
Deeply obliged.
We'll see it. It's possible.
Tuesday.
No, Tuesday. Deeply
Tuesday.
obliged.
18.
Item number 15.
My lord, in this, your lordship has already heard the matter last time, my lord. Here, in this matter, my lord, the accused person was arrested on 29/7/2025, and bail application moved before the learned court below.
I had heard.
Yes, it
Remember?
was to be,
My lord,
No, I don't think I have heard.
for default bail, my lord. And that was rejected by the learned special judge.
No, there's no order of mine. But
No,
it
no.
sounds familiar.
Yes, madam, what happened?
Sounds familiar, but that default bail,
happened, madam,
that period.
This section that was in case of the accused persons, it was section 21B, madam, by the investigation agency. But while bail application was disposed,
On the ground that it's commercial quantity.
yes, madam. Now,
Yes, sir, I had
Yes,
heard this, but
yes.
how come I did not pass any order?
no,
no, my lord
no,
has not passed any order.
I said my lordship heard this matter last time also. Here, madam, what happened? The prosecution, the police department, while investigating the case, my lord, in case of the accused person, the substance were measured with the vials and the plastics.
If it is measured with the vials, then it is 373 grams.
Yes.
No.
Now, my lord,
No,
But after-
277 vials of contraband measuring 373.4 grams.
Yes, my lord, it's page
Several soap
24, type
cases.
copy is page 24, my lord. That would be better, but otherwise it's a handwritten is very difficult to see. So, now, one, my lord, that has been measured, my lord.
Hmm.
That comes around 82.47 grams. And number 2, 3, 4, my lord, those were measured with the vials. And anyhow, my lord, the police have definitely, after measuring with the vials and plastics, they have said it's a 21B, my lord.
Diary has come.
My lord, it has been culminated into charge sheet, my lord. Charge sheet has been filed during the pendency, my lord.
In any case, perhaps, perhaps he had become entitled to default bail.
Yes,
perhaps, because-
my lord, yes, my lord, initially they.
But at this stage, we'll not say default bail.
Yes,
We'll
we are
dispose
not
it of
saying,
generally.
I'm not saying that, my lord, though,
Charge investigation is completed, intermediate quantity.
yes,
But that quantity aspect, we have to be clear.
yes, my lord,
Otherwise, 37 will come.
yes,
You have to
ma'am.
make a determination.
Yes, ma'am.
Right? So help me with that. This soap cases, right? All soap cases, 7 soap cases, which is 27 grams, 11.5 grams.
No, all
so on, so
those
on.
comes around 82.47 grams.
Okay,
Number one.
2.47 grams.
Yes, and my lord,
100 grams of VLs.
here, my lord, the vials have been measured, my lord. That's the problem here. My lord, since charge sheet has been filed, my lord, because your lordship, not only the quantity, 27A is also there, my lord, regarding
Where?
illegal trafficking, and my lord.
No, 27
Since
require 37.
yes, my
No,
lord.
what are the
But my lord, this charge sheet has been filed, but TCR has not been called for, and charge sheet we have not received, my lord. My lord,
no, section is only section is 21B, I think.
yeah, 21.
27A is not there.
That, my lord, whether in charge sheet, my lord, the police may have added the new sections also, my lord. That we are not aware, my lord.
That
But
we
I don't,
Yes,
my brother, why he submitted. We have checked with the trial court, my lord. Charge sheet has not yet arrived in the trial court. They might have processed the filing of charge sheet, but
That we don't know.
No, the trial court we have checked, my lord. Charge sheet has not come.
Then you take instructions.
Yes,
You
ma'am.
take instructions.
Yes, otherwise, my lord, the accused person ought to have been released, my lord, under the or the
That's why,
armed right.
regarding the quantity aspect,
Yes. When the police itself,
you just, I will recite and you just cross check. 11.33 grams of 38 grams of 11.38 grams, right? 3.12 grams, 3.98 grams. Honest color measuring 131, inclusive weight. Inventory documents are there. We'll need the chart, we'll need the case diary.
my lord, charge sheet we needed, my lord. It has
No,
been coming with charge sheet,
The
my lord,
inventory
and-
documents are there.
Yes, my
Are
lord.
the inventory documents, they kindly see the quantity from the inventory documents.
Okay, man.
Because the magistrate certifies us, right?
Yes, man.
That is why that's a very important step
Yes, man.
for both sides. The magistrate certifies about the quantity. So we'll start from there. That will be our quantity.
Here, my lord, the
Should
seizure
be-
memo, it's not completed, my complete one, my lord. The seizure memo has been given, the arrest memo has been given, my lord.
No, sampling would be there.
Yeah,
Sampling would be
but
there.
it's not there in the case diary, my lord.
Sampling is done immediately, right? So it's, or soon after it's done.
My lord, here the suspected heroin cape, yellow envelope marked S1 weight 5.31 grams. And then S2, 3.87 grams. And then S3 type of Nictor 10 Nictra Jefen IP 10 mg containing 10 tablet, each bearing batch number T1.
Kindly help me with that, because heroin I know we have dealt with all many times. There's nitrozepam, which is a psychotropic substances. What is the quantity bracket of that? What is commercial quantity? Because I don't know about nitrozepam.
That your lordship, also
That you
for
have
that
to
I have to
check.
take instruction because your lordship is not there in this column also, my lord, in the.
Can I have a look at diary? He was arrested on, sir,
29/7/2025.
209.
Yes,
209, 2020.
7, 29/7.
Okay. 897/2025.
Yes,
8,
it's more than 100 days.
9.
More than 100 days. But the FSL report is there, madam.
Just a minute. So now it's basically a dispute about quantity.
Yes, yes.
Uh, 82.47 grams found in soap cases.
Yes.
And without soap cases, it is 82.47 grams.
Okay.
Without the soap cases.
Yes.
Is it? Is it?
Yes.
Okay. And then with the vials, it is 373.4 grams.
Yes, madam.
Then without vials, what will be the weight?
Madam,
But we cannot guess, right?
that's the problem, madam. That's why.
We cannot guess,
Yes.
right? We cannot guess. They should. That's why it should be available in the inventory has to say this.
Madam, the FSL.
Otherwise, it will not be an inventory. It has to say the weight without the containers. This is the case diagram.
Yes, madam. My lord, for tablet nitra feza, my lord, the total weight should, small quantity would be 20 grams, my lord.
20 grams.
Yes, my lord.
And commercial
500 grams.
500 grams. Just a minute. No, charge sheet has been filed under 27A also.
My lord, that we don't know as on that, my lord, because charge sheet has, TCR has not been called for. Only we have the case diary, my lord. During the pendency of this case, the charge sheet has been filed. my
But,
lord.
under the aforesaid facts, it's just last part of this. You have
Yes.
this copy.
Yes, because my lord,
So has been established against.
because your lordship, the
So-
other
so-
person alleged to have procured the suspected drugs from this person, my lord, the present applicant, my lord.
Mhm. And section so and so has been established under G10 Biswas. So we'll need the charge sheet.
Yes, my lord, that's
It
what I-
indicates that most probably charge sheet has been filed under 27A also,
Yes, my lord.
because it says like that. We'll have to get the charge sheet. Otherwise, copy of the charge sheet, no?
Yes.
This CD, will you retain the CD? You retain the
Yes, we can retain it, my lord.
Call for the charge sheet.
Yes, my lord.
Then we'll be.
Yes,
clear.
my lord. Copy of charge sheet, ma'am.
Just wait for 2 days.
Yes.
Which police station this is? Which court will be now?
Special court UPR,
Stuff.
NDPS special court UPR.
In this matter, the petitioner side contends that the quantity of the contraband in question falls in the bracket of intermediate quantity, and therefore, from the date of his arrest on 29/7/2025, he had become entitled to be granted default bail. But by the order dated 11/8/2025, bail was rejected. And due to the learned trial court holding that the quantity falls in the bracket of commercial quantity. The case diary has been received. And the case has been, there's a prima facie case has been found against the present petition under section 21B/27 A/29 subsection 2 NDPS Act. Full stop. However, no any charge sheet is on record. It may be mentioned here in that section 27A of the NDPS Act attracts the rigors of section 37. While retaining the case diary, call for scan copy of the charge sheet
Yes,
from
ma'am.
the concerned learned court, which is
Special court UPR, my lord.
special
And-
court
yeah.
NDPS UPR. Let us fix it on Tuesday or Wednesday.
Tuesday, my lord.
Tuesday.
Tuesday, my lord.
Tuesday.
Yes.
Can you mention?
Oblige, ma'am.
Lordship. My lordship, a little correction,
please, my
lordship,
lord.
in item number 14, lordship, item number 14, lordship, the charge sheet has been submitted before the CGM court UPR, lordship, so. it-
CGM court.
Yes, lordship.
So I think
CGM.
CGM UP,
Much
not
obliged.
session judge UP.
May I please, my lord? My lord, in the morning, my lord, I mentioned, my lord, item number 17, my lord. Matter may adjourn, my lord.
No, it is about to be now. On what grounds you are seeking adjournment? Because it's interim
My
bail.
lord, I will
CB
physically
case
appear, my lord. On 17th, my lord, 17th or 20,
It can be,
21.
this matter can be disposed of, my lord. See, we have retained the CD, my lord. CD is there, my lord, and
You want to come physically?
Yes, my lord.
Let him come.
okay, my lord.
Okay, no problem.
Okay, ma'am.
What
You
should be
come
date may
physically.
fix, my lord?
You want it on 17th?
Yes, my lord.
17th, you give your suggested date since you're
Yes,
coming
my lord.
from
17th, my
outside.
lord. 17th.
That's item number 17. I do 6 an adjournment due to some personal difficulties. The learned counsel for petitioner appearing online. 6 an adjournment. It's praise for fixing the matter on 17th, and he would like to appear physically. The case diary is received and shall be retained. The interim bail granted to the petitioner by the order dated so stands extended in the next date of listing.
Yes, my lord.
My lord. Lordship. Oblige, my lord.
Oblige, ma'am.
This, Mr. Sharma, this matter, I was just going through, and I'm not talking about, of course, the file is voluminous, not in that sense. You know, I was just thinking, so I want to take your learned opinion, that should we ask them to make a paper book? Even if paper book is made, it will be a multi-volume paper book. If all the documents are needed. If all documents are not needed, then it won't.
All documents are not, some of the papers can be avoided. Only most of papers can avoid.
Then
I'll take 20 minutes, my lord, I'll finish. And lordship, then lordship, before the next day, lordship, if the paper book is needed.
no, I think it will not be possible otherwise because this voluminous thing, so we have to see now which papers. Let us ask them to make a nice paper book. It will be very beneficial for the hearing for that.
In that case, my lord, subject to my lord, what lordship says, and my lord says.
I thought last evening that I will ask you, of course. Take your,
Lawyers suggest which are the papers necessary because.
that will, otherwise they will prepare a whole thing. It will be a 5-volume paper,
No, it's not.
wasting everyone's time.
Some of the documents are repeated also.
Yes.
There are.
Let me start the hearing, lordship. Lordship will get it. Lordship, I will not, lordship, take to lordship to all the document, lordship. I have given only 5 orders, lordship. It is there in the.
No, let it be identified and we'll have a.
Only five documents
No,
are already given.
because other councils, all the assisting councils are from here. So, to keep it partnered, actually, it will go there.
Lordship, I talked to the registry, lordship, even if it is partnered, lordship, lordship can take it.
I say I have to rise at 3 today and this bail is there.
I know, lordship can take up there in Guwahati already.
No, let the paper book, very wise course of action. Kindly identify the papers and get the papers identified, and with that they will prepare a nice paper book. On the next day you can do the hearing. That will.
Otherwise, lordship not required, lordship. Lordship has some hurry, lordship. We have some urgency, lordship.
No, that both are true. I have also have some time constraints, but paper book for the purpose of the hearing, wherever I have seen paper books, very nice paper books I have seen here. And there also which is made. But there are criminal appeals which I have handled.
Second appeal,
very systematic paper book really assist. Really assist. I found the paper books to be very good here.
Lordship will give me 10 minutes at least in the second half, lordship.
Okay, introduce it. Introduce the matter, but not part-heard, right? It won't be part-heard.
Lordship will hear me, then lordship will decide. Okay. As the lordship will finish it today itself.
Item number 26 for delivery of order.
The criminal petition of the state is allowed.
My lord.
I think charges will have to be framed.
My lord.
In my opinion, the materials.
My lord.
So accordingly, direction has been given.
My lord.
Trial will proceed.
My lord. Deputy Rest.
Item number 27 for delivery of order.
The settlement petition is allowed. Both are allowed.
Item number 13.
Instruction.
My lord, that one is passport matter, my lord. Bail matter. My lord, I verified that document with the IO, my lord. So the same that later which my lord have perused. That is the same measure later of this arrest intimation.
Okay, fair enough. You can dispose it of. We can write. The heard and learned public prosecutor. The invoking the person under 483 BNS. The accused petitioner herein, Marley Ingo, is seeking regular bail in connection with Nirujoli PS case number. We have written some part. We have written a part. Nirujoli seem to have. I have dictated this part, not to you. Nirujoli PS case number 77 of 2025 under section 3082/61 BNS, read with section 13 UAP Act. Stop.
Which was, my lord,
The learned
later renumbered as SIT case number.
Full stop. Subsequently, upon the investigation being taken over by the SIT, the case was re-registered as SIT case number PHQ CB PS NRG, page 2 of the petition. Let's leave from there. Full stop. The learned counsel for the petitioner contends that he is not going to the merits of the matter and seeks. I dictated this. I dictated this part. I had dictated. I think I had dictated to either Cebu or this part you take from there. The Learned Petitioner Council has drawn my attention to a copy of the notices under 47/48 BNSS, which was given at the time of his arrest. It is also mentioned in the notice that the same was also given to brother of the accused, namely Rekeningo. The grounds of arrest mentioned were mentioned as follows. You just replicate this. No? Replicate this. Only the ticked part, not the whole thing, only the ticked part. Full stop. The case diary has been received, right? Case diary.
Yes.
The case diary has been received. The learned additional PP.
SPP SIT.
Sorry, the additional SPP SIT, Special Public Prosecutor SIT, contains that while investigation is going on, it has revealed significant materials against the accused persons, including the present petitioner. Full stop. A status report is also submitted for perusal of the court. Full stop. With regard to the contention of the petitioner side, the learned special PP fairly submits that upon checking the scan record has been received.
Scan record.
So then investigation is completed.
No, my lord.
Not completed.
Investigation.
Upon perusing the relevant portions of the case diary, also the notice on the 47/48 has been found, and it is the same notice which has been annexed with the petition. Full stop. In this case, it appears that a single notice has been given to both the accused as well as to his relative/brother in compliance with sections 47/48 BNSS. If the contents of such notices meet the constitutional standards laid down, the giving constitutional standards, giving the same notice to the accused as well as relative might not be a fatal irregularity. However, full stop. However, it is always desirable and necessary to furnish two different copies to the accused and to his relative under section 47/48 BNSS respectively. Full stop. In the instant case, upon perusing the grounds mentioned as narrated above, I am of the considered view that it is not a case of complete non-compliance, as some grounds have been given. However, most of the grounds given are appear to be generic in nature, rather than specific, rather than specific to the accused concern. In terms of the settled law laid down by the Honorable Supreme Court in case of Prabir Purkasta and Vihan Kumar. No, citation we will get from the comma. The grounds of arrest in sufficient detail and specific to the accused are required to be provided to the accused at the time of his arrest and to his relative. Full stop. It has been held that this is necessary to comply with the provisions of Article 22 within bracket 1 of the Constitution. Full stop. The aforesaid case laws have also laid down that in the event of non-compliance or compliance which does not meet the stipulated standards, the subsequent detention of the accused would be untenable, and entitling him to bail. And it has also been held that such a entitlement to bail would prevail, even if there are some statutory restrictions, such as Section 37 of the NDPS Act. In the instant case, the penal provision of UAP given is Section 13, and therefore the rigors of 43D5 proviso, 43D5 proviso of the UAP Act shall not apply, as the said rigor in terms of that section applies only to the penal provisions of the UAP Act falling in Chapter 4 and Chapter 6. We'll stop, starting with Section 15 of the UAP Act, which defines the act, which defines a terrorist act. Full stop. In my considered opinion, the aforesaid grounds provided to the accused would fall short of the stipulated standards in terms of the law laid down by the Honorable Supreme Court. Therefore, I find the accused to be I find it necessary to grant bail to the accused at this stage on those technical grounds. Accordingly, he is allowed to go on bail of rupees. Let it be a little more, 50,000, 60,000, 50,000, or should I be more? 50,000, 50,000 with one surety of the like amount to the satisfaction of the concerned learned court, which would be which court, and subject to the following conditions. He shall cooperate with remaining investigation. He shall be available for trial in the event of charge sheet and commencement of trial. Number 3, he shall not hamper or tamper with evidence. Violation of the bail conditions might entail cancellation of the bail. Another condition, he shall not try to influence us or threaten them. Okay, bail petition stands allowed and disposed of on the aforesaid terms.
Grateful.
Next. Okay.
Item number 2, it's a password for the timing matter.
16 is over. 16 is over. 13 is over. One bail is left. Okay.
Not to be cancellation of bail impossible for mere violation of bail condition.
Instruction.
Lordship, as per the lordship, the instruction lordship, I could not receive properly, but it appears that lordship, the process is not been followed, lordship, as per this order, lordship. So lordship, kindly lordship is revert it back to the same court, yes, lordship.
Okay.
And
that can be done. What happens
yes,
now? He has to be released.
No, lordship, because on the
The
Monday,
bail
lordship,
cancellation?
Monday is CC date is fixed for CC, lordship. So on Monday, that if the court has honorable court kindly remanded back to
if I set aside
as per the due procedure law, lordship, it may be followed.
No, just asking you, we're learning together. Suppose the cancellation of bail is set aside, then the bail revives, right? So his liberty again revives.
No, sir.
So that means he will be taken to be on bail again then.
Lordship, will
and he has to submit. He has to be directed to be released on submitting fresh bail bonds.
Lordship, it may be directed to the lordship appropriate court, lordship, session to.
Earlier, we have already filed another bail application before the appropriate court, but
Just
rejected
the
the same.
notice not being issued is not lordship ground for the lordship bail will be lordship allowed, lordship. Because lordship only ground was not been followed, lordship, because he was granted bail, but certain ground was imposed, strict condition was imposed.
Okay, I'm saying that without sitting aside the order, you remand it back.
Yes, lordship.
And notice should be given to him.
Yes, lordship.
And he should be heard.
Yes, lordship. That would be more appropriate, lordship.
And thereafter, if it is cancelled, then he remains in custody. Otherwise, he'll be released on bail at a learned trial court.
It will follow lordship in that lordship. What the ground, because only the ground is that lordship here he has come, Lordship, because notice has not been served. Otherwise, Lordship, his Lordship ground of arrest or ground of bail, Lordship, he was violated.
This is which court this was?
Session Court, UPI, Lordship.
UPI, so
Yes,
that can be done fast.
Yes, Lord.
That's okay. So, Uni, so 611 order, you just take first three paragraphs the same.
Lordship, I want to share something with additional Supreme Court order, which is reliable in this case, Lord.
Notice has to be given to him.
Yes, no notice was issued,
Hmm.
not any hard by both sides.
Notice has to be given to him.
Yes. Without notice, the learned special just NDPS have
Notice has to be given and he has to be. No, then whatever it will be permissible to set aside.
Lordship, Lordship may not set aside, Lordship, only to revert it back to the Lordship, to the appropriate court, Lordship, to the session court to.
No, because see,
to follow the due
if the cancellation of bail is found to be suffering from violation of principles of natural justice, right? So it becomes untenable, isn't it? It has to be set aside. The person will, and if it is set aside, the cancellation, then his liberty revives again. So that is one point of view. Is appealing to me more, that's that part.
Lordship, if Lordship has set aside, Lordship.
But he has to be noticed again.
Yes, Lordship. He should be remain in bail, Lordship, remain in jail, Lordship, just to ascertain that he has the justice has been served or not. That was their Lordship. But Lordship, if Lordship has granted bail now, Lordship, then Lordship, it is a different matter, Lordship, because here, Lordship, they have only challenged the why notice not been served. Otherwise, Lordship, he already violated the bail condition.
mere violation of bail condition is not permissible as per law.
No, bail condition. Yes, no. There's a process involved, adjudicatory process involved.
Yes, the process
that bail conditions.
Yes,
The informant or the prosecution may allege that I have violated bail conditions, but I may be able to convince the court that I have not violated.
Yes.
Right. So it involves a kind of
Yes, that
deliberation,
was,
right?
That was not.
So the court may not cancel my bail
Yes, yes.
if I'm able to convince that. Though he has said, actually, I have not violated, and this is why I have not violated.
That procedure not been followed. That was
procedure.
their Lordship.
So don't you think we should, because he was on bail, right? So his bail was cancelled without following procedure. So in a way,
In Monday, Lordship, that is already.
Are you agreeable to that? Are you agreeable to
No,
that?
Lord.
You're not agreeable to that.
Already he is since July, August 28th, he is in jail.
This order was in August.
August 28th, annexure 16, Lord. In my petition.
And Lordship, he was again arrested, Lordship.
Bail, he got bail in that
Yes,
case.
Lordship. In the Lordship.
Already granted bail.
Anyway, so this Hage, learned additional public prosecutor, fairly submits upon instructions that in the proceeding pertaining to cancellation of bail, the accused was not noticed. Next paragraph. It is well settled that once a person is granted bail, regular bail, the cancellation thereof leading to curtailment of liberty is undoubtedly a serious matter, and the principles of natural justice have to be read into such a process. Full stop. Otherwise, there would be violation of the constitutional values under Article 21 as well. Full stop. I have perused the order dated 28/8/2025. This is the order, right?
Yes, annexure, page 16, annexure C.
From the order also, especially para 2, no any notice or hearing of the accused is revealed. Thus, the instant case, the cancellation of the bail of the accused was not as per proper procedure, and by complying with the principles of natural justice, which required giving him an opportunity to explain as to why his bail should not be cancelled as prayed for by the prosecution. Accordingly, the said order dated 28/8/2025 is hereby cancelled, is hereby set aside and quashed. Full stop. Consequent to such interference with the impugned order, the impugned order, in exercise of powers under 528 BNSS, read with section 482 BNSS, 483 BNSS. The accused is allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the concerned learned court, which is Session Judge UPA, full stop. The learned trial court is at liberty to issue a notice to the accused, and after conducting a hearing, adjudicate the issue of cancellation of his bail, or otherwise with regard to, let us give the case number also, with regard to which case number?
NDPS case number 11 of 2025.
And the special NDPS case number 11 of
2025.
2025. The instant criminal petition stands allowed and disposed of on the aforesaid terms. Okay.
Lordship, here, Lordship,
Oh,
hearing is fixed on 17/1. He maybe appear, Lordship.
Yes.
The bail conditions will have to be subject to the conditions. The bail is subject to conditions. The number one, the accused will appear before the learned court below on the next date and subsequent dates. Number two, he shall not hamper or tamper with evidence.
He should not allow to leave the jurisdiction of law.
Usually I don't impose territorial jurisdiction because it creates rigidities.
No, Lordship,
Every time they have to
even
come before
the
us.
accused person,
Yes, country you can say. Sometimes, some cases, country you can say. If you have to take permission if you're going, or submitting passport is again something more stringent than that.
NDPS case, Lordship. NDPS usually, Lordship, that the violation they have we generally do, Lordship.
as per record, Lordship, from the date of initiating the case, he is regularly attending before the Honorable Court as and when required. So, no such required as
Lordship,
prayed
then
by my lord.
date may be fixed on the 17th, it is fixed for the hearing, Lordship. Then he may
including the next date fixed on 17/11. That I have already written. Another thing you write, this the learned additional PP submits that the upon interference with the impugned order, the matter should be remanded back for necessary for noticing the accused, and that at this stage he should not be released on bail. This item number 16. Would you like to write? You like to start this thing? You can call them. 16.
Yes, Your Lordship.
My lord, the CD was called for, my lord. I have received the CD, my lord.
Vigilance matter?
Yes, Your Lordship. So I have already appeared before the SIC twice, Your Lordship.
Okay.
Yeah, on October 8 and November 5. So I'm already cooperating with the investigation officer, Your Lordship. And since, Your Lordship, this FIR has been launched in the year of 2021. So, but no investigation was carried out for almost 4 years, Your Lordship.
In the meantime, the applicant retired from the job, Your Lordship, in 2024. And he has been denied for the pensionary benefit, Your Lordship. So because of that FIR. So because of that only, Your Lordship.
Disciplinary, he's also facing disciplinary proceedings.
Yes, Your Lordship. Not exactly disciplinary proceedings.
His pension has.
Yes, and comes under that only. So because of that, Your Lordship, we have filed the criminal petition for the quashing of that FIR. On 12/9/2025, the notice has been issued. So after that, on 30/9/2025, we received a notice under Section 160 of CRPC from the SIC, Your Lordship. So we have appeared before the SIC on 8 October and 5th November, Your Lordship. So basically, they have sent that notice because we have filed this criminal petition. For almost 4 years, they did not do anything. They did not file any charge sheet. No investigation were there. So suddenly after they received the notice, then only they send the notice to us, Your Lordship, under Section 160. So Your Lordship, now he's a retired person. So he is in 61 years old, Your Lordship. And because of this case, he's facing difficulty in pension also, benefits also.
He's, what is his name? Gyamar Dima.
Yeah, Gyamar Dima. He's a retired DFO, Your Lordship.
Just a minute. Next comment, please. He was granted interim bail.
Yes, Your Lordship.
Yes, sir.
My lord, I received the CD, my lord. My lord, this is the third time that they have filed the anticipative bail application, my lord.
Okay.
Back in 2021, my lord, they have filed a AB application, my lord, which was dismissed, my lord, on merit, my lord.
Okay. Same matter?
Same matter, my lord. Same case, my lord.
21. On 8/10, it's granted interim bail.
The bail was heard at length, my lord, and it was rejected on merit, my lord. AB application 122 of 2021.
So you are opposing the bail?
Yes, my lord. My lord,
despite appearances.
Thereafter, my lord, when this bail application was rejected, my lord, thereafter they again filed a bail application being AB number 135 of 2021, my lord. It was withdrawn on the ground that they have filed an SLPB for the FX court, my lord. And
this was the first AB?
That was 122 is the first AB.
First. Then another one which was withdrawn.
Yeah, which was withdrawn, saying that an SLP is pending before the Honorable Supreme Court. Now, it seems that they have withdrawn that SLP as well, my lord. Now, they have come again with this AB, my lord. And this application was filed on 8/10/2025.
I think another aspect has come to my mind.
My lord.
Guide me.
My lord.
This has to go before the same judge, since but he's not available in the bench now.
No, in my humble
But he's
understanding.
available in this court.
Therefore, my lord, I was just coming to that, my lord. This application was filed on 8/10/2025, my lord. It was a vacation bench, my lord. I was out of station, my lord.
Oh, this judge is not here.
Yeah, therefore, my lord, it was in a vacation bench. Now, it's the petition was not served to me, my lord. And the matter was again listed on 4th of this month, my lord. So since I was not aware of it, my lord, I've taken time and called for the CD, my lord. And it was again listed on therefore yesterday, my lord. Yesterday, my lord. Now, I have received the petition copy today itself, my lord.
Nice.
Your Worship, from our side, it has already been served to the other party, but we came to know today only from.
Should I keep it for another day if you want to argue? I have some time constraints, but I can hear to a limited extent.
My only humble
But it
submission
has to be disposed of today.
Yes, Your Lordship. Since we are already cooperating with
I
them,
will
Your
not be
Lordship.
available.
Yes,
It has to be disposed of.
My only humble submission is that, my lord. Now, I have not. I've just gone through the petition today itself, my lord. Now, there is no whisper in the petition saying that earlier bail applications were filed, my lord. This is a subsequent bail application, my lord. And if there is any new material, no circumstances, they cannot come, my lord. There is nothing. There is no whisper about the earlier 2 bail applications.
In the affidavit.
Yes, my lord. And they have to come with the new grounds, my lord. They are coming with the same old grounds, my lord.
Investigation is still going on?
Yes,
it
Your
is still going on.
We are, sir, Your Lordship, we are already cooperating with the investigation officer also. And since we have filed a criminal petition, actually we have filed for the interim protection, but we have been suggested by the Honorable Court that it's better to file a AB again. So that's why we have filed it AB on the same date only, Your Lordship. And Your Lordship, moreover, because of our criminal petition, the quashing of the FIR, they have sent a notice now just to. In fact, we are the one who is suffering. We are the depriving person, Your Lordship. Because of us only, we have filed criminal petition. Now they are coming into action, Your Lordship. So the notice has been sent on 12/9/2025, and then only they have sent on 30/9/2025, Your Lordship. And again, whenever they called us, we go there and we gave our whatever statement they needed, we gave it, Your Lordship. And it's been 4 years, Lordship, the charge sheet has not been filed.
True. That
Yes,
is definitely a legitimate grievance.
Yes, Your Lordship.
The question is whether
At this stage, will the investigation be hampered if the interim is made absolute?
My lord,
Yes.
I've gone through the CD, my lord. There are so many incriminating materials in the CD, my lord.
Because it's an alleged corruption matter.
Yes, my lord. It's
So it has to
corruption.
be, no. And mere allegation of corruption does not make the person,
Sure.
doesn't mean that he is corrupt or something, but it has to be investigation. Investigation has to be seen. The materials has to be seen, right?
Yes, there are ample materials, my lord. My lord, see the CD, my lord. The total amount was 3 crores, 50 or around 3.5 crores, my lord. It was meant for KEMPA, my lord, Compensatory Afforestation and Fund Management and Planning Authority, my lord. He was the DFO at that point of time, my lord. The funds were released. All these funds were siphoned off in connivance with private contractors, my lord. One of the accused person here in my lord. Now, during the course of investigation, nothing has been found, my lord. There are no plantation, nothing, and there is no plantation, nothing. All this money has been siphoned off.
Oh, the money was for plantation.
Yes, my lord, for afforestation, my lord.
Your Lordship, I would like to correct here the learned.
You have a right to.
Yes, Your Lordship.
Let me finish first.
He has summarized the findings against the petitioner.
Yes, my lord. Yes, my lord.
Oh,
If my lord come to page,
it will require some time. Let them go through it then. No problem. Take out a sheet.
after page 65, my lord, of the CD, my lord. My lord,
I'll come to all the aspects now. Both sides I'll come to. Don't worry. Bail number. VA number. This one is VA number.
154. AB number 154.
Okay.
My lord, in the CD, my lord,
yes.
After page 65, my lord.
65.
There is an status report, my lord.
Yes, that's
my lord will find all the materials here, my lord, and the amount which was siphoned off, my lord.
You want to read any relevant part? I don't want you have to take the trouble of reading the whole thing.
My lord.
But I will read it. But if you want to point out any specific serial numbers, we can read it together. Investigation.
Para 3, my lord.
Just a minute.
Para 3, para 6, 9, and 10.
There are 3.
Yes, my lord. It has been made clear during the investigation that the LSDFO, Sri so and so, failed to observe the SOP for executing Kempa project under Tape VFR. VFR is, my lord, village forest reserve, my lord. Tape is the village, my lord, where that project was to be implemented, my lord. And 5 also, my lord, was
Huge transaction found in his bank account.
Yes, my lord. The modus operandi was that, my lord, he would
54 lakhs.
yes. The money was transferred to the private account of the co-accused, my lord. The contractors, and it was taken out from there, my lord. There was no any implementation of the project, my lord. And the measurement books which we were supposed to sign, my lord, he had allowed one of his forest guard to sign all those documents, my lord. He signed it and it was in his name, my lord. It is in the statement of
Forest guard.
The forest guard. But he was the DFO, my lord. It has to be routed through the RFO, my lord. But surpassing the
IFO is inspector.
RFO is the arrest officer.
Range post.
But
RFO.
the statement of the RFO says he doesn't know anything about the sanction of this project, my lord.
It was routed through the
No, it came to the DFO.
Guard.
It has to be routed through the RFO, my lord. But he did not even inform the RFO, my lord, the concerned RFO, my lord. And all the measurement books were signed by the forest guard, my lord, who is supposed to be one of his relative, my lord. In fact, my lord,
it's investigated by the ACB.
ACB, my lord. In fact, earlier the IO which was investigating this case, my lord, he has been transferred, my lord. So now new investigation officer has been appointed, my lord. That was the reason for a delay, my lord.
Lot of materials.
A lot of materials are there, my lord.
Lot of materials are there. Lot of materials. May not be a fit case for anticipatory bail. Investigation is still going on.
Yes, my lord. Yes, my lord. And then
I'll hear you.
But apart from that, also, my lord, they have to come with a new ground, my lord. They filed it 2 times, my lord. It was rejected, my lord. And now they're coming with a subsequent bail application, my lord, AV application. They have to come with the new grounds, my lord. There are no new grounds, my lord. There's content of judgment from the apex court, my lord. But I would not like to burden this honorable court with the judgments and all.
Okay, no.
May I, Your Lordship?
Yes.
Your Lordship, the money which has been issued in 2013 to 2019, Your Lordship, in the year of 2013 to 19. And the petitioner assumed charge as a DFO of that division in 2017, Your Lordship. In the midway of the project, Your Lordship. Whereas the money already has been transferred in 2013 to 19. And he has been appointed as a DFO in 2017, Your Lordship. By that time, already the project was in hard midway, Your Lordship. And your lordship, in fact, the deputy commissioner, it's in our petition. In your lordship. Page number 9. Here also, your lordship, in 21(8).
Your petition, right?
Yes, in my petition, in my bail application. Your lordship. 9, page number 9, your lordship. Para 9, and your lordship. That further, cooperating with the vigilance clearance certificate dated 21/8/2023, the Deputy Commissioner, Namsai, separately issued a no objection certificate dated 16/9/2024, confirming no encroachment or damage or abatement of encroachment by the petitioner and no objection to settlement of pension, your lordship. So, your lordship, our main concern is because we filed the criminal petition for the quashing, only they are doing their work, your lordship. If the case is very serious, they could have do in last 4 years, your lordship. They were not active for the last 4 years. And because I have served in a government sector for last 50 years, your lordship. And in this 50 years, there's nothing against me, your lordship, no complaint, nothing, your lordship. Just because I was there as an active DFO in that time, your lordship, because of that only. And that also, I transferred there in 2017, your lordship. Moreover, the money already, the scheme transferred already in the 2013 to 19, your lordship. So it was the duty of the SIC to check whether the transaction is between me or between the contractor or whether the transaction is between with other person or the previous one who was as a DFO in that particular time, your lordship. So they did not do any investigation. Today, suddenly they came with so many documentation, your lordship, because we have filed a quashing criminal petition. Just because we know that, we are a genuine person, just because I was there as a DFO, so I'm suffering, your lordship. My 50 years, I have given my 50 years. Now I'm in that age. I can't even walk properly, your lordship. And I'm fighting for my pension, your lordship.
The pension, that.
Yes, your lordship. And your lordship, it's moreover, if they are so genuine, they could have do it, the investigation and everything. In this 4 years, your lordship, why they were so silent for the 4 years?
Definitely, there is undue delay.
Yes, your lordship.
One thing, his statement is available.
Oh, yes,
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 your lordship.
yes, madam.
It must be there, yes.
Madam, may kindly come to page 42, madam.
42?
42 in the CD, madam. CD number 25, madam. He has admitted the fact that, madam.
42, it starts from there.
Yeah, it starts from 42, madam. CD 25, madam. If my lord sees B, my lord, close B, may I read it, my lord? Okay, I'll start from the first, my lord. The funds were sanctioned with the item-wise cost. I do not remember the exact figure as of now. The same is mentioned in the sanction order. The Kempa project of the above funds were executed during my tenure as DFO Kurungkume. He admits that, my lord. It is contradictory to what my land finance
Which one?
stated, my lord.
2017 to 2019. I did not say that
43.
that time I was not there. But the money has been transferred in 2013.
I do not remember the exact figure. The same is mentioned in the sanction order. The Kempa project of the above sanction funds were executed during my tenure as the DFO Kurungkume division from the year 2014 to 2019. NIT was not plotted in the instant Tape VFR project, as we normally do not float tender in Kempa projects. Sri Gyamar Khora was forest guard posted at DFO Office Koloriang. In the allegation, it is mentioned that the entries in the MBs were made by Gyamar Khora instead of RFOs. In this regard, I admit that I recorded the entries in the measurement book, but asked Mr. Gyamar Khora to put his signature on the measurement recordings. He is a forest guard, my lord. And he is the DFO, my lord. But it has in the measurement book, it has to be the RFO, my lord. He surpasses the RFO and asks one of his subordinates to sign the measurement.
He was the forest guard.
He is forest guard. The RFO and deputy RFO competent officials for recording the MB entries, but I manage Sri Gyamar Khora, forest guard as the RFOs and deputy RFOs posted in the division were not sincere on duty, though I do not have any written record to substantiate my claims. Now down below, my lord, after C, my lord, 3. Bill 3, down below, my lord.
43.
43, my lord. Bills were prepared based on the MB entries as per AOP's allocation. The bills were drawn by check transferred in firms MS JP Enterprise, proprietor MS Dohu Okyo, wife of Sri Dohu Oppo. Dohu Oppo is one of the accused person, my lord, in this particular case, my lord. And MS BB Enterprise. The bills transferred in the account of JP Enterprise and BB Enterprise were distributed among the villagers contracted by themselves as per plantation was undertaken by the villagers, my lord. But when the verification was done, my lord.
Field verification.
Yes, my lord.
Field verification.
Yes, my lord. In the total area for the project was 510 hectares, my lord. 510 hectares, my lord.
Okay, then.
Now, out of that, my lord, when the field verification was done, my lord, there is an DFO office building and there is a guest house, forest guest house. And the rest land is the WRC fields of the villagers, my lord. WRC, red, white,
no plantation.
No plantation, nothing, my lord. Now, the manner this has been done, my lord. The money was sanctioned. He transfers those money to the private accounts, to firms, and from there they both takes the money, my lord. That is the modus operandi, my lord. No project, nothing, my lord. All the amounts were siphoned off. And there are statements of the press guard as well, my lord. He has admitted that yes, the DFO has asked him to sign the MB books, my lord. It is in the statement itself, my lord. It is in the CD, my lord. And even the statement of the RFO is there, my lord.
Project was mainly for plantations.
Yes, my lord. Afforestation, my lord. Village reserve, my lord. In Kurungkube district, my lord.
Anyways, Sarma, Santosh. All. I'll dictate the most part. Last part, I'll go through it. I'll just keep the CD.
Well,
despite limited time, I'll go through, but some parts I will tell her. Yes. This order will cover a lot of things. The factual part is already written.
Yes, madam.
Judge. Meanwhile, we can proceed with the other matters.
Otherwise, also whether the application is maintainable.
Today only you'll get the order.
It is maintainable.
It will be maintainable, but the thing is that previous, because we sometimes the court can also fall in false positions because if the earlier bail petitions are not revealed, because it might have been allowed or rejected, might have been rejected, then the position needs to be known.
Yes, madam.
Anyway, just I will dictate today only. You'll get the order. Let us proceed with the other matter.
My lord. Deeply obliged.
Next. 7. Please come, sir. Matter number 7. Mr. Majumdar, I'm sorry you are come for so long.
Yes.
For so far away and not matters could not be heard, but you can just introduce the matter.
Yes, my learning is for the petitioner. If your lordship desires, I can also make
Yes,
this, but my
I just went through a bit of it. Of course, I didn't get time to go through it.
My lord,
Student election.
My lord, what has happened? The whole matter relates to election of a students' union. All Nishi students' union. The election is to be taken in such a manner that there are branch students' union, and from the branch, delegates come. Delegates are recommended.
I'm for the petition.
My learned is for the petition.
You can introduce the matter. Yes.
My lord, in this case, the respondent number 1 is holding the post illegally, the president of the All Nisi Students Union, holding the post of president by violating 4 court's order,
Okay.
4 interim order of the court. Now, he was elected illegally, and in fact, the petitioner number 1 is supposed to be the president, the petitioner number 1 before this court. By an injunction, the respondent number 1 was restrained from as a to the exercising power of the president post pending the suit. This injunction was appealed against.
Appealed against, but the appeal was not successful.
Not successful. Against that, High Court.
Appeal
not successful.
Injunction revisions are always against. And the third
So the appellate court said prima facie case is there. High Court says all prima facie cases there. Now, what is stay? The 3-round complete. Going back, the same judge who has said that the trial court has discussed the 3 principles, prima facie case, balance of convenience and irreparable loss in a very nice way, detailed way. The same judge has said there is no prima facie case now. Going back, when the matter was going back from the High Court and the appellate court, now he said that there is no prima facie case. So, Lordship, may please come to page 14 of this note.
This one?
Yes, this one, Lordship. Page 14. I will not take your Lordship to anything. I have just given 4 order, Lordship.
We are there for you, definitely.
Only
Whatever,
10
it's my
pages,
first
Lordship.
duty.
I will show you 10 pages,
You have
Lordship.
come for so far away. Sorry, you have to wait for so long. Anyway, so let us understand the matter. Let's see how far we can go.
There is 2 union, Lordship.
Page 14, right?
Yes, page 14.
Page 14.
My lord, my learned friend should get one. So, I have given a copy to my learned friend also. The All Nisi Students Union is a Nisi Students Union body formed under the Article 1 of the Anstey Constitution. There's a constitution, and that is the sacrosanct document, Lordship. This is the sacrosanct document. This is the only document, Lordship, rather I said. And this is redacted in 2024. The Article 3(4) of the Anstey Constitution define the federal unit and the branch students union, in short the BSU, recognized by the ANSU under the Article 17 of the ANSU Constitution. So this is the Constitution and this is a sacrosanct document. This, if it is true, is a branch students union for a federal unit of ANSU as defined and recognized under the Article 3(4) and 17 of the ANSU Constitution. The ANSU Central Executive Body, the position at the election, as per the Article 11 of the ANSU Constitution, the ANSU Central Committee Executive comprises 26 electoral position and portfolios, including the president. The term of the ANSU Central Executive Body is 3 years, as per the Article 13. Lordship will take note of this, because the whole germ of this case is this. I will show from the Constitution.
3 years.
3 years. Under Part 9 of the ANSU Constitution, by Article 20 thereof, it is provided that before the expiry of a term, 3 years of ANSU Central Executive Body, the ANSU General Conference is to be conducted for an election of the new Central Executive Body. Clause Roman 2, Roman 3 of Article 22 of the ANSU Constitution envisage that the incumbent president of ANSU is to be appoint members to the Election Enforcement Committee of Delegate Registration Committee for the ANSU election, which is responsible for enrolling the delegates who shall vote in ANSU election. So they have to send the list. Clause 4 of the Article 22 stipulates that the name of the delegate from the various schools in Nisi inhabited district are to be submitted by the concerned BSU. The voters delegate composition from BSUs and the school is provided under the Article 7 of Article 22, which interiorly entails the BSU are entitled to nominate 20 delegates, higher secondary school 5 delegates, delegate in secondary school 3 delegates. The Constitution This 6 is very, Lordship will take note of this. The constitution, the composition, functions, and the office of the 6th election commissioner, chief election commissioner for an Ansun election are governed by Article 21 of the Ansu Constitution. So there is a chief election commissioner, Lordship, and the chief election commissioner is the head. And it is in a train, Lordship, there is an engine and rest are the bogies. So my learned friend client, they are bogies. So the chief election commissioner is the engine. He is the respondent number 2. My learned friend is appearing for 5 and 6, 4 and 5. And the respondent number 2 is the chief election commissioner. And here in this case, Lordship, this man, he has admitted, he has filed an affidavit on oath. He said that it is all illegal, everything he has written, Lordship. In one paragraph, Lordship will get it.
Respond number?
Respond number 2. Before the trial court, and we have filed an additional affidavit, Lordship. We have bring that record, Lordship. And he has written that in violation of the court's order, I have done all this. I feel sorry. And all that. And that is a documented, Lordship. Now there is no problem. Did the 7th general election of substitute election in the petitioners 2 and 3 is in the 7th general election of substitute conducted on 16/9/23 and 17/9/23. Petitioner number 2 and 3 were elected unopposed as the substitute new presidents and the general secretary, respectively. In this election, the candidates are of 4 individuals, that is, Mr. Rai Taha, Gokia Tayum, and Tai Tahun, and the Rio Gagi were rejected for the post of President, General Secretary, Assistant General Secretary, and the Vice President, respectively. On 10/11/23, after the petitioner number 2 and 3, along with their co-office bearer, have been administered oath for their new position, the present respondent number 10, the then President of Ansu, illegally set aside the election result and announced a fresh election to be conducted within 30 days. There the things turned, Lordship. We have already taken oath after the election. As on that day, the aforesaid decision, dated 10/11/23, setting aside the result of 7th FCSU general election is suspended. Lordship will take note of this 10/11. By an ad interim injunction. These are court orders, judicial order, Lordship. And attain finality, Lordship. Dated is suspended by an ad interim injunction dated 25/10/24, passed by the Learned Civil Judge Junior Division, Kra Dadi District at Palin. The said order was appealed against by the aforementioned Mr. Ray Taha, Gokia Tayun, Tai Tahun, and Rigyo Gagi, filed civil appeal number 01/2024 before the Learned District Judge. At cause so and so at 0. And the said appeal was dismissed as not maintainable. Lordship, so that once that is dismissed, the interim order attains finality. By the judgment and final order dated 1/11/24, which was attained finality, Lordship. There is no appeal against that. So now the Lordship will take the note of paragraph 10. This is very important, Lordship. And no one can dispute. No one can dispute, not under dispute. Thus, owing to the aforesaid order dated 25/10/24 and 1/11/24, it is beyond evil that as of today, the petitioner number 2 and 3 are the lawfully recognized and elected President and General Secretary of FCSU through the lawfully completed aforementioned 7th general election of FCSU. And here I pausing for a moment, Lordship, this is complete. That attains finality. Nobody has challenged that. That order is there. Now, Lordship, this is the second part. After the interval, what they have done now. This paragraph, the FCSU delegates for the 16th Ansu General Conference, para 11. The 16th Ansu General Conference for election of the new Ansu Central Executive Committee 24 to 27 It is why I'm saying, Lordship, it is I am now 2025 November. Already 6 months illegally enjoyed, Lordship, violating the court's order. Petitioner number herein has contested this election as a candidate for the president post. The Electoral Enrollment Committee, EEC, for the same was notified by the then President Anshu, that is the instant respondent number 10. And this committee comprised of the instant respondent number 6 to 9. Lordship, in this respondent number 6 to 9 filed an affidavit in the suit and said that everything was illegal in front of us. All these illegal things has happened. They have filed an affidavit before the court, and we have bring it on record, Lordship. This respondent number 6 to 9. The election commissioner for the said election was notified by respondent number 2 by an appointment order dated so and so, whereby he interiorly appointed the instant respondent number 2 to 5 as the chief election commissioner. Lordship, get it. Returning officer, presiding officer, and polling officer respectively. Now, Lordship, I am reading this line again at the cost of repeat. Whereby he interiorly appointed the instant respondent number 2 to 5 as the 2 is the chief election commissioner, 3 is the returning officer, 4 as the presiding officer, 5 as the polling officer respectively. So all these persons as per the constitution is under the respondent number 2. On 13/10/2024, the present petitioner number 2 and 3, being the president and the general secretary of FCDSU, has sent a list of 51 delegates for FCDSU and the school covered under the FCDSU jurisdiction to the EEC. Surprisingly, the aforementioned Mr. Ray Taha and his associate had also sent a list of their delegate to EEC on behalf of the FCDSU, who is contained the name of 54 delegates. Now, those persons who was restrained by the court's order, they have also sent. Mr. Eita and his associates has illegally incorporated 3 extra names and the delegate and the so-and-so. So these 54 delegates were sent by whom? Somebody who was illegal and against whom there is court's order, Lordship. And there nobody who can send the list. And they have participated. These 54 people has participated in the election. In view of the aforementioned order dated 25/10/24 of the learned civil judge, the petitioner number 2 and 3 addressed a letter dated 29/10/24 to the Anshu election EC, whereby they intimated to the EC that any nomination sent by Ray Taha and his associates would be rejected by the EC in view of the civil court's order. We have been informed. And he has received. It's a matter of record. Then this title suit number 17 of 2024. That how
came to be filed.
Now, yes, this is not the instant suit, Lordship, this is another suit. This is another
suit.
This is very important, Lordship, this is earlier suit. This is the foundation rather. Lordship can see, this is the foundation. Backdrop of the violation of the injunction order. On 9/11/2024, while forwarding the name of the delegate voter except the FCDSU, the instant respondent number 6 and 7, that is the member of the Electoral Enrollment Committee, issued a notification by which it referred respondent number 2, that is the Chief Election Commissioner, who is the highest authority, the question of deciding whether petitioner number 2 and 3 51's delegate or Mr. Ray Taha's 54 delegates should be permitted to vote in upcoming Anshu election. This paragraph, Lordship will look into this paragraph 16, Lordship will take note. Now, Lordship, para 17. By a decision dated 12/11/2024, the instant respondent number 2 to 5, that is the election commission member, rejected the aforementioned 51 delegates nominated by FCDSU on 16th Anshu's election under the signature of the petition number 2 and 3. So, the court's order was that the petitioner 2 and 3 is the authority, they will send the name, and they have rejected the name of the petitioner number 2051. Now, on the other hand, the respondent number 2 and 5 accepted 54 delegates nominated by the aforementioned Mr. Ray Taha and his associate, against whom there is a final order, finality lordship. The decision was on the teeth of the aforementioned injunction order dated 25/10/2024. Then, on 13/11/2024, the challenging both the decision of the so-and-so, this 1724 was instituted by the instant petitioner number 22 2 and 3, 22 orders, including 4 co-elected office and so-and-so, 14 co-elected office bearers, 4 nominated delegate and 4 nominated candidate before the civil judge number so-and-so at UPA, along with his application misbearing number so-and-so, and the order 39 rule 1 and 2, therein inter alia, praying an interim decision to the instant respondent number 229 to allow the aforementioned 51 delegates nominated by the petitioner number 2 and 3 to participate in the 16th ANSU election as voters. B, to restrain rate as 54 delegates defendant number 9 to 63 therein from participating in ANSU election. The present respondent number 1, who is the incumbent president of ANSU, was not a party in that suit. Lordship will take note of that because till then he was not a president. He was not elected. He was nobody till then. Because the election process was not started then. So he was not a party there. These aforementioned injunction A and B were granted. Lordship will take note. This aforementioned injunction A and B were granted by the expert interim order dated, the order of mandatory and prohibitory nature dated 14/11/24 by the learned civil judge junior division Papumpere district, while suspending the operation of the above notice decision dated 9/11/2024 and 12/11/2024. This order was duly communicated and duly received. Respondent number 229 herein. Since the respondent number 229 did not show indication of following the order, an application for execution, Lordship, though it is unheard of, Lordship, in Guwahati also we normally not file this. There is an application for execution, Lordship, of the injunction. And by order dated 14/11/24 was filed by Miss case number so-and-so by an order 20/11/2024, the learned civil judge junior division Papumpara district directed the deputy commissioner and SP capital complex Itanagar to ensure compliance of the aforesaid injunction order dated 14/11/24. Till date, this order 14/11/24 and 21/11/24 have not been challenged before any superior court, and as such, they have attained finality in the eye of law.
Just a minute. Let us see the impugn order one.
Yes, Lordship.
Because that's the base.
Lordship, I have given separately, yes, on the top. Yeah,
Just a minute. What is the petition?
on the top, Lordship, there are 4 I have given. Lordship, don't have to take any other document, Lordship.
Yes. Paper book will be necessary in this one. Definitely. But
in a clip,
not
Lordship, in a clip, Lordship.
yes, I've seen it's before me. I'm seeing something else. Revision. I'm sorry. Cost title.
Lordship, that is page 23, annexure 1
Just a minute.
of the document. I have given it separately, so in a clip.
24/3.
The impugn order is 24/3/25. In the clip, I have given separately, Lordship. Yes. Before that, Lordship will take the page 1049, that is yet volume in the volume, Lordship, order dated 28/1/25, where the injunction was granted. In the top, Lordship, 28/1/25, in the top. Lordship, get it?
This was the first order.
Yes.
First order.
Yes. Yes. It is the page 1049 of the volume.
Yes. Let us see this order first.
It is beautiful, perfect order, Lordship, by Munsib. The contention of the learned council, Lordship get it?
It is the contention of.
Yeah, it is the contention of the learned counsel as shown for the so-and-so, concluded the election of so-and-so in Mrs. Students Union was done. So the, in a flagrant violation, the court order that the so-and-so, he goes on to state that the complying the court order so-and-so, and the so-and-so, all this is the argument of the Mr. Sonar, the counsel for the petitioner. On the other hand, on the next page, Lordship will get the counsel for the respondent number 1 to 9 submits. Then that Mr. V. Datta appearing for respondent number 10 also has argued. After hearing all the parties, Lordship,
Just a minute.
this order has passed.
Let me go through it myself. These orders of the court were passed in the earlier suit.
This is the present suit,
In
Lordship.
the present suit.
This is the present suit, Lordship. Mize case 25 of 24, title suit 21 of 24. This is the current suit.
Non-intervention.
They violated the order of the title suit number 17 of 24, Lordship. What I have read there, Lordship. That is at 14/11/2024. Lordship can see the second page down below. I have also perused the application.
No, just.
Lord, I'm sorry.
No problem. As submitting. Yes. Accordingly, the operation of the result notification is operation of notification dated 29/12/24 suspended. This one is also barred from representing himself. This means against this order, they went in appeal.
Yes.
Right? Appeal. And
Yes.
And the appeal judgment is?
That is, that interim was rejected on 10/2/25, Lordship. That 41/5 is rejected on 10/2/25, the third order, Lordship. Second, I have serially given 1, 2, 3. In the second, I have
28/1 I have read.
21, 28,
order
then the 10/2.
10/2.
10/2. Rejection of stay, Lordship, under 41/5, they file an application for stay of the interim order. 10/2.
Okay.
10/2. Here before the appellate court said, heard both the learned counsel peruse the impugn order dated 28/1/25, seen that the impugn order of the learned civil judge junior judge UPA has relied on the golden principle, that is prima facie case, balance of convenience, and the irreparable loss for grant of the impugned temporary injunction order. Accordingly, at this stage, this court is considered opinion and sufficient cause is not made out to grant a stay of the impugned order. So he has come to the same court, Lordship, in the civil appeal number 2 of 2025. In the Miss case, he has 41/5, he has rejected the stay. Against this, they came to the High Court. The number 3, that is in CRP 15 of 2025, order dated, that is serial number 3, Lordship, in that clip, Lordship. In CRP 15 of 2025.
Yes.
Lordship may direct come to para 17. Internal page 13.
Internal page
13. Internal page 13
of the judgment.
Yes. or
Para?
para 17. This is the end of the matter, Lordship, from the High Court. However, it is observed that while passing the injunction order, the learned trial court has discussed the three golden principles in detail, and the learned appellate court, while rejecting the prayer for stay, also noted that the trial court has thoroughly considered the principles. Accordingly, the appellate court observed that no sufficient cause had been made out to grant the stay of the impugn order. To ensure a quick resolution, the appeal was fixed for hearing on 4/3/25 with the intention to dispose of it. However, on 4/3/25, the hearing could not be proceeded, and the next date for hearing was 13/3/25. Thus, in the event that the learned appellate court fixed a sort of the appeal with the aim of ensuring the prompt disposal. Then furthermore, it is observed that there is no jurisdictional error, patent illegality, or miscarriage of justice in the order passed by the learned appellate court while rejecting the prayer for stay. This is purely an intellectual, and there is no reason to interfere with the order passed by the learned appellate court at this stage.
So it was rejected.
And rejected. Now the impugned judgment is serial number 4, that is order dated 24/3/2025. It is the height of perversity, Lordship. The same judge, same court, who has rejected that.
Page number?
The page number, Lordship, 23, and the relevant page number 23, annexure 1, it was written, Lordship. It is serial number 4, in the clip, Lordship. In the clip, it is annexure 1, like page 23. It is written. And it is order dated 24/3/25. The last one, Lordship has read this 1, 2, 3, the last one. There are 4 orders in the clip.
Four.
24/3/25, Lordship.
I had found this just now, but
Just after the High Court order, when the High Court order finished, Lordship, then.
thereafter 10-2.
No, 24/3.
Yeah, the High Court order ends, then 10-2 starts.
It is the page 23 of the record, Lordship. Page 23, Lordship. In the top, it is written as page 23. Lordship.
Oh, yes, yes. 24-3, yes.
Yes.
Yes, yes.
Lordship, may
This was
straight come to page
judgment is
36.
pronounced, detailed judgment is first considering the observations. Prayer and install appeal is Iman. And impugned order granting temporary injunction is set aside in quash.
Yes.
Yes.
Then.
Giving rise to this revision.
Yes.
Right?
So, Lordship, may straight come to page 36. There in this order. Page 36. Para 9. From the above, it is observed that the learned civil judge junior division UPI in the impugned order dated so-and-so in Mizje case number 25 of 2024, in title suit number 21 of 20, stated that the respondent appellant here violated another injunction order dated 14/11/24 of another suit in Mizje case number so-and-so, in order to come to a decision of prima facie case being made out by the applicant, in order to grant the impugned temporary order. In addition, it is seen from the 9/12/24 passed by the learned court below in Mizje case number so-and-so, in title suit number so-and-so, that with regard to the allegation of violation of the said injunction order dated 14/11/24, the respondent appellant said miscellaneous application filed under order 39 rule 2A and section 151 is already pending before this court. Now, this court is aware of the principle of law that the contemptor violator of an order of a court should not be allowed to enjoy the and retain the fruit, contempt and the contempt and the violation. However, the fact that the appellant have violated or not the injunction order was dated 14/1 has to be decided after conducting a summary trial as per the provision of order 39 2A by the learned court below. Thus, stating that the injunction order dated 13/11/2024 is violated by the respondent in the impugned order dated 28/1/25 would amount to predetermination of the allegation of the violation said injunction order the 14/11/2024 is a perverse lordship. Perversity should be some limit. And additionally, coming to the decision that prima facie case is made out to grant temporary injunction in favor of the appellant. On the basis of the said determination, in the considered opinion, this court cannot be considered just and reasonable. From the above, it is considered opinion in the court that the learned civil judge UPR ordered in law by stating and predetermining that the injunction order dated 14/11/2024 is violated by the respondent. And therefore, prima facie case is made out for grant temporary injunction in the impugned order that is so and so and so and so. Hence, this court is of the considered opinion that the order dated 28/1 so and so passed by the learned so and so in which the case number so and so is not just and proper and need interpretation. And lordship, in paragraph 10, the court said, in law, not a single law is discussed. No prima facie case, no balance of convenience, no irreparable loss, nothing.
So I think we'll have to close.
Yes.
So what do you do? I think your idea is very good. Paper book will be necessary. I think otherwise the hearing will be very difficult, right? So depends on when you can come next.
Lordship will keep the pardon, Lordship. Even today, Lordship, I have PA. Lordship.
No, you said it's a very simple matter. In 10 minutes, you'll be able. It's not simple.
No,
It'll
my learned friend, has prepared.
It may be simple. Yes, that is.
It runs up to.
You are such an experienced civil lawyer that it's simple for you, not for lesser mortals like us.
No.
Seriously.
Lordship, if Lordship do not want to keep it pardon, Lordship, then the matter be taken up tomorrow by the other branch, Lordship. I have some.
It can.
Tomorrow I cannot manage.
See, Lordship, 1 lakh student, Lordship.
My lord, I was here.
For the civil case.
Hold on.
My lord, I consider to my learned friends request that please stay here for tomorrow. I have stayed. Tomorrow I cannot stay, my lord, by it. This will be too much, extension of too much.
Lordship, you will come on the online, Lordship, let my part be completed.
This is not a case.
Lordship, this is because this is a civil case.
I can argue.
This will continue like this.
No, actually.
My lord, prima facie,
Earlier also one court has heard.
Difficult and easy, that's another thing. But thing is that it involves, some issues, and there's an earlier round of litigation.
Yes,
Violation of integrity.
There are
So it will take hearing.
My lord, there are 5
That's why I asked.
This suit, this
VC hearing might be difficult in this case.
Yes.
Physical hearing may be necessary.
Yes.
Anyway, you have given a very good suggestion. At least that much I can record. That I have not gone sufficiently into it. You have just introduced me. You have taken me to the no. The thing is that you have taken me through all these. But the thing is that how did the basic thing arise? What was the initial dispute? And why civil suit was had? What happened in the civil suit? How injunction came to be filed? And then what happened? Then that's why the first few paragraphs are very important.
Background is necessary.
Be taken up by the other court tomorrow.
Yeah, you have an opportunity. He's an authority in civil law. Anyway, heard learned senior counsel.
I cannot.
Shibu, heard learned senior counsel. Yes, Swarma, learned for the revision petition agreed by order dated so and so passed by the learned appellate court, whereby the injunction granted by the learned civil judge junior division UP Abide order dated ... was set aside and quashed. Considering the fact that there is a large volume of documents in the file, it would be convenient for the purpose of hearing and adjudication if a paper book is prepared. However, the learned counsels have been kind to submit that the relevant papers, only relevant papers, paper book will prepare.
Yes.
The relevant papers can be identified. That they would assist in identifying the relevant papers, and on the basis of these relevant papers, the paper book in single or more volumes can be prepared.
With only relevant documents.
My EAB recorded lawsuit. I do not want a paper book. I have some urgency lawsuit. That may be recorded lawsuit. because I'm engaged by my client.
Then
So
that's
Lordship,
okay. If you have urgency, I can fix it on Monday or tomorrow.
Tomorrow, Lordship,
I'm not, tomorrow I cannot. my lord.
Lordship, only earlier also one court heard. After hearing Lordship, he said that I have some personal problem, I will not take up.
No, I did not say. I did.
Good for one
I did not say it was the
No,
honorable
see,
judge.
you know, with all respect to you, see, I said that I have time constraint. So you said that I will introduce in 10 minutes, but if sometimes if the matter requires extended hearing,
If my learned friend
it's-
urgency, let it be in the next week, my lord. 19th.
since the matter requires extended hearing,
He has waited for such a long
you
time.
started at your
as per his convenience.
you started at your own.
Whenever he wants.
No. Since the matter requires extensive.
Earlier also as per his convenience.
No, since the matter, what I'm saying.
I have, my lord, I have stayed back. Yesterday I stayed back.
Don't be
Also,
no, urgency has to be respected.
Party said, let the matter be fixed on such and such day.
Yes, it
And
was fixed
accordingly,
yesterday.
Then we come.
It was fixed yesterday, but it was not fixed for 3 days, my lord. It was fixed yesterday, but it was not fixed for 3 consecutive days. My learned friend should understand. Yesterday, today, and tomorrow, it was never fixed, my lord, like this.
So there is no civil bench. What to do?
No,
I
for
am
you,
here. I am here.
I do not know. That
that is not my way. It is
I
not
was-
because of that.
I
have
was
taken
here
time.
yesterday, my
I
lord.
am voting for.
I had no intention.
Partner from UV there, from Guwahati, are good there.
See, your respected senior counsels, I am not saying that I indicated the constraints.
Next week.
I indicated the constraints, and
Fine.
so that and I also said that because I have perused a little bit of it, I had the prima facie feeling that this will require some hearing. That's
My
why
lord,
I said that
Your lordship will just
it may not be able to be completed today, and since it's it's a Arunachal matter. And it may be difficult through VC, so I said I will not keep it part-time.
Right.
So, but still you started at your own risk. But the thing is that this paper book, the learned senior counsel for the petitioner submits that there is some urgency in the matter and preparation of paper book may delay the matter.
my lord, either 19th or 25th. whichever
However,
day is
considering the voluminous nature of the documents, the paper book, the court finds it necessary to have a paper book. However, it may be prepared at the earliest so that there is no delay in the matter. I can give a date tomorrow onwards, since I haven't.
Tomorrow
But you cannot say Monday, Tuesday, any
Wednesday,
day.
my lord, Wednesday 19th.
Wednesday, I can give. Next bench will be there. Wednesday, you can hear. I think 2-week roster will be here. From next week,
The earlier, I'm telling you, Lordship, earlier the local judges has taken up this matter. 8,000 Nisi was the voter. And they said this someone is relation, someone is known. So local judges is very difficult. He called me to December after hearing the matter for 1.5 hours. Then he said that this is local for a local.
I understand. Councils have
My lord, then in
so
that
much
case-
work to do.
My-
The effort should not be wasted. This I understand.
My lord, in that case, my lord,
Lordship, only one thing be written. If the office will not prepare the paper book before that, the matter will go on. In the name of the paper book, the matter will be dragged for another 1 year. That will be
No way.
no way, Lordship. That is
The learned
that is
senior
my-
counsel submits that if there is delay in the preparation of the paper book, the hearing may be proceeded with.
my lord, may I suggest one thing? My learned friend is indicating that on local judges find it difficult. On 24th, my lord, Honorable Justice Manish Chaudhary is coming.
I think next week is coming. I'm
Next,
not
no,
sure
not-
of the-
next week, my lord. Next week, my lord. Honorable Justice Surana and I'm sorry.
No, sorry, going.
Kardakate and Honorable Justice B. Habung.
Me?
B. Habung.
Oh, both are
Both are local. And from 24th, Honorable Justice Manish Chaudhary is sitting.
Susmita Fukan count is there, Lordship.
Yeah, I think I heard she's coming tomorrow.
Next week, Lordship, Susmita count is there.
Then let it be next week, 19th, my lord. I can.
Only thing, Lordship, my problem, Lordship, earlier also I have argued.
Yes, that's right.
Then the local judges say
Yeah.
we have problem because all these students
Both are local judges
Yes.
next week.
Next
I
Next
think,
week.
but I heard Madam is coming. I also heard.
Then
I've forgotten the
then
roster
let it be
actually.
on in the next week, 19th.
Should I? Fix it?
19th.
Yes, sir. But only Lordship, the registry will prepare before that, Lordship. That's my. Or Lordship can allow us to make a paper book, Lordship. We will make it, Lordship. If the registry has some problem.
Let the petitioner make.
At our cost, Lordship.
No, I mean.
They still do, I have no problem.
On
Lordship.
prior things that, since the matter is stated to be, since the learned senior counsel for the petitioner reiterates that the matter has some urgency, therefore, the paper book shall be prepared on a priority basis.
And then 26, Lordship, because on 3 days they will not make the paper book, Lordship.
And I
25th,
I would humbly suggest you to take a date, take a date where the judge comes from a 2 week close, 2 week period. Just that you date so that the hearing judge is here for 2 weeks, not 1 week.
Yeah.
Because we never know, some division matters can
26 is good, Lordship, 26 and 27.
I have no problem. Fix the matter on 26.
Already, Lordship, in the order, it is written, Lordship, to make a endeavor to dispose of the matter on last order, Lordship.
If it is possible, can it be disposed of at admission stage? Pleadings are complete.
It is already there in the order, Lordship, last order.
That I leave it to the judge, because since I am not list the matter on 26/11 for admission in the admission column. So this written argument should be in the record. And can you help in preparing?
Only Lordship will accommodate. We are coming for 3-4 days. At least top of the list or something like that. Already, Lordship, all criminal matters, we are sitting up to 3:30.
As the first admission matters. Only a few motions are listed here. That's not a problem.
Lordship, but I have a year, Lordship, only all these.
No,
at this stage, may I, my learned friend has argued for about half an hour. Let me say one or two sentences, Your Lordship, permit me.
Yes.
My learned friend is thinking, or his client is thinking, that he is entitled to an injunction. Only in the rarest of rare cases, temporary injunction is granted in favor of a person who is not elected. I am elected, my lord. And I am elected. I'll come to that. I'll come to whether it is illegal or legal. I am elected. He is not elected. Now, Supreme Court says, my lord, while granting a temporary injunction, there is always a risk, because ultimately, if the suit is dismissed, what happens? There is a risk of being wrong. I'll show the judgment, my lord. What is that?
Lingering
Initially, you pass the order restraining someone to hold the office for which he has been elected, and subsequently, if the suit is dismissed, you are preventing someone, and now this cannot be, my lord, compensated.
Yes.
Now the reverse cases, my lord.
By money.
Yes, my lord. Now the reverse cases, my lord. Just give me 1 minute, sir. Reverse cases, if the injunction is not granted, and ultimately in the trial, if the suit is decreed, then also there is a risk. Now the Supreme Court says you have to weigh which one is having more risk.
Balance of convenience.
Yes, my lord. Then the Supreme Court says, my lord, so you have to weigh which one is having more risk. And here I am elected, I'll be prevented, and he is not elected, and he is not seeking a direction that I should be declared elected, because he has lost in the election. He participated in the election, he lost it. Now he is saying that it is illegal after the election is over. Now, what is his case, my lord? I did not want to open, my lord. It is necessary, it is to open. He says that 51 delegates from my side were prevented by not incorporating their name in the voter list. 54 persons from this group were allowed to cast vote by incorporating their name in the electoral roll. So and my lord, my learned friend's client lost the election by a margin of 91 votes. Now, it is the presumption of the plaintiff that all these persons who were prevented from casting their vote by not incorporating their name in the electoral roll would have voted, number one.
For him.
Yes, my lord. It's a presumption. And there is a direct Supreme Court judgment on this. Supreme Court says, in India, there is no presumption that all these persons will go and cast their vote. First. Second, even if they go and cast their vote, what is the guarantee that all these persons will cast the vote in your favor?
This is one. Secondly, my lord, here is a case. It is not a case where total votes were 100 or so. Total votes were around 2,500, 3,000. Now, those persons who were illegally, according to them, were allowed to cast their votes. Where is the case of the plaintiff that all these persons have actually cast? You are saying his election is illegal because these persons were allowed to cast their vote. Merely because these persons were allowed to cast the votes does not mean that these persons cast the votes in my favor, because there were 5 candidates, my lord. And yes, my lord, in a given case, there can be a case for temporary injunction if you can show, let's see, this is the ballot paper, and these are the persons who had cast the vote in favor of you, and these are the persons who have come forward and said that yes, all of us would have cast the vote. Nothing.
Okay.
And you are asking for a temporary injunction, and you are saying that the election is only on the ground that the election, the order directing these preparation of electoral roll was not complied with. Assuming for the time being, assuming for the sake of argument that there was a violation, and the electoral roll was prepared in violation of that 14/11/24 order. Even then, my lord, plaintiff has got no case, I'll show, my lord, and plaintiff is not entitled to any temporary injunction. Suit itself is not maintainable, I'll show, my lord. The suit itself is not maintainable.
But the matter is not taken up. So, and the polling officer and presiding officer has agreed.
Their admission, my lord, doesn't.
The polling officer and the presiding officer.
Their admission.
Polling officer and presiding officer's advocate is arguing all this. Now, there is a connection with the winning candidate that the polling officer and presiding officer, there is a connivance. This shows that the presiding officer and polling officer is arguing all this. That the polling officer and presiding officer is the servant of legislative one, respondent number 1. This shows the
Mr. Deuri.
This shows lordship the presiding officer and polling officer. Who is he?
To locate, identify the relevant.
Yes, my lord, let the
can do it tomorrow also.
both sides.
Tomorrow, yeah. Tomorrow,
counsel for
tomorrow you won't
sides,
be here, no? He'll be here tomorrow.
Local council lordship.
Local council
Local
can.
counsel, if
Because
the
tomorrow,
conflict we suggest.
court will be free.
Yes.
So they can do it peacefully, and do it.
All these local, everybody has a local council lordship.
No problem.
They will.
Don't worry.
It's good.
I
that
understand some matters are inherently, a little contentious. That's right.
Contentious and lordship, the head breaking already lordship. My learned pen client has already, there is a search sheet,
I'm
2-3
sorry,
affair.
I had to disappoint you.
Lordship,
But the thing is that these things are also great learning experiences, this kind of matters. But anyway, kindly.
But I'm sorry, lordship was supposed to go, lordship. We in some time, lordship. We folded and lordship. I'm saying sometime, lordship. It is for the interest of the client, lordship. We have to do, lordship, because these people are suffering, lordship.
You must have grasped the matter so well, that you must have, as a very good civil and experience, you must have grasped it very well. You have done well to file a written argument. You maybe, Mr. Deuri, you can also help, sir, because I have always believed, from my practice days, that a written argument, it is not possible to prepare in all cases, but written argument, if it is prepared, it preserves the effort of the lawyer. Preserves the effort. In Western countries, it's what people I know,
and makes the job
it
convenient.
preserves the effort. Tomorrow, suppose the matter, suppose sir is busy, you have to do the matter. You can read that and do the matter. It preserves the effort. That's very important. Because so I've seen this arguing before a judge. Then again, the matter says, where's the effort?
Lots of effort.
Other matters. Okay, thank you.
Deeply obliged.
That we have filed the written argument, it should be there, otherwise from the record.
Written argument has been filed, it's on the placed in the record.
Well, 26th I'll come in if it, my lord, goes to the next
It's
day.
Wednesday. Wednesday. You over within 3 days we can finish it. We can finish it within 3 days. And if paper book to get it, Sarma, get it prepared. Paper book will, it always, it's very. It attracts everyone, looks that, discipline. I've seen very good paper books here. So do that. Other matters, I think we have to take. Other matters, you have to take, kindly take your dates. Okay. And all interim orders will be extended. Don't worry about that. It's not your fault.
Please, and
Deeply obliged.